Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
As the agent for Peyton Ansley, John Milton, you are indicating to me that you're quite familiar with Peyton Ansley, John Milton, and that's basically you. Is that correct?
I am the agent authorized to represent Peyton Ansley, John Milton, as written in all capital letters.
All right, and you understand for my purposes, that language doesn't make any sense. So
No, I do not.
I understand. Okay, well, I'm telling you that. And so I am, until you disabuse me of the notion, I am inclined to believe that you are both the agent and the person. So. And it's
I'm not a person. I am one of the people. Thank you.
Okay, thank you.
Okay, thank you. Not a person, I'm one of the people. Welcome to the Court of Public Opinion. Welcome back to the Court of Public Opinion. I'm the Recovery Addict. Thank you very much for joining me this afternoon as we take on part 2 of today's session, I guess, in the Take Care of Maya case. This is a civil suit. It's gotten spicy already. It's slated to go for a long while. We're not sure if it will ever go to the jury. There may be a settlement eventually. We don't know, but it's been interesting. I've just been outside working a little bit and bringing in groceries and all that. I have weird sound effects happening here. Okay, they're going away. All right, it's all right. Okay, I was bringing in groceries, and I will have you know I brought in milk, bread, mushrooms, but no pickles. Some of you might know the significance of that. Anyway, so no pickles today. Lacey, you did not. Oh, wait. First of all, hang on. First of all, couple things. We've got a couple things to put up on the screen. Our winner, when it comes to the internet. Can I get this on the screen? There we go. Jill Ballard, first in chat today. Congratulations, Jill. I think you've won before. I definitely recognize that profile picture. I think you're a repeat offender, not necessarily a habitual offender. Habitual offenders make it a habit to win several days in a row, but you're working towards that. And you know, some people like to build their app sheets, and you're getting there. You're getting there. You really are. Congratulations, Jill. First in chat, responsible for all things IP related, and as somebody pointed out, also responsible to make sure I stay awake during the live stream. I did sleep in a little bit this morning, so usually that makes me tired of all things. So if you can just be in charge of that, that would be great. Also had a huge super chat from Mr. Ivan Victor, who's back. He said, "Hey everyone, sorry I had dropped off the map like that. I'm okay. Family's okay. I had to deal with some things from my past. Please don't ask now. But now, no, I'm not in trouble. Life is finally back to normal. I'm back ready to deploy my annoyance on y'all." All right, thank you, Ivan. Good to hear that things are good with you, and thank you very much, my friend. Wonderful to see you back here. Let's see. No pickles. That's a crime. It might be. This is a small shopping week, though. It's just like 8 gallons of milk, 6 loaves of bread, and mushrooms. I think that was most of it. Let's see. I need one of the 13th Jurors Recovery Addict stickers. How can I buy one? Jody, we've only made the ones that we sent to Brandy, and I think after the 10K celebration, we'll look and see if that's something that we can do in the future. I wouldn't want to. Here's the thing. I don't want to sell something that has her logos on it and it has her month progression, the 13th juror logos on it. That wouldn't be right of me to sell something with that. That's why I made them and sent them to her so she could give it away. That way I don't know. I'll have to talk to Brandy. If she's good with it, we might figure out some way we can get those done. But it was sort of a special edition thing. Didn't have plans to sell them, but let's see. Milk and mushrooms. That's we have a ton of other stuff already purchased. Okay, speaking of what's going on, we're back in court. Let's see if we have we have our objection counter. Let's see if we can put on the label for the objection counter. Boom, there we go. We're up to 133 objections. We picked up about 20 today so far? About 20, which is a little bit, I guess that's probably a little bit on pace with what we had before. So that's
Someone left
that's
this
awesome.
0 on my chair, handing it back to the teacher. I'm top brown noser.
Someone left this $20. I'm not sure why it said 0. This $20 on my chair, handing it back to the teacher. I'm top brown noser. Thank you. I'll keep it up at the front of the class and see if we can find out who it belongs to, Ayden. Thank you very much. I object. I'll object. Let's see. It has been spicy this morning. If you missed this morning, Brandy mentioned October 8th. Okay, I Rescue Dogs. That's exciting. Brandy has a 10K celebration, which honestly, it happened before she was ready for it. So she was not expecting to reach it so fast, and she is growing by leaps and bounds. Her channel's doing great. We're so excited for her. But they're going to celebrate 10K on October 8th, so we'll have to pencil that in and get, because I'd like to attend that for sure. That would be wonderful. Milk and Mushroom sounds like an overpriced baby store. Here's what happens, Ella. This it makes more sense if you realize that my wife shops for 2 weeks at a time, and she's done the 2 week shopping, and then this is the off week. So we just need to replenish the things we burned through really fast, and that was milk and bread. And then she happened to have not got mushrooms during the big week, and so she picked those up as well. So that's how it works out. We have plenty of food. We're not going to survive on milk and mushrooms or bread. Ivan also came with gifted 5 memberships. Ivan, thank you very much. Let's see, those went to Arlene Wiley, Polly Furman, Brenda Meyer, BP Van Oss, and Obsessed with the Truth. Congratulations, all gifted memberships by Ivan Victor, who is back. He's back. It's good. Wonderful. Ivan won the lottery, apparently, says Be Kind Tiger. I think he's just in a great mood. He's good to be back. Do we know what dish the mushrooms go in yet? I do not. I asked her again, and she said, now that you've seen the package, because I carried it in from the car, and she said, now that you've seen the package, do you recall this? And I said, well, I remember the package vaguely, but I still can't think of what food you hide these in when you feed them to me sneakily. Rudy Patootie says, time flies so quickly. Glad to be a member of this great community. 5 months, Rudy. Next month, your courthouse goes yellow. Thank you so much, Rudy Patootie. Good to have you here. As I was saying, testimony has been so spicy so far this morning. It's been wonderful. We're really looking forward to how this afternoon starts off, because it starts with cross-examination of our witness, who is this amazing doctor. Which somebody help me on the fact pattern here that led up to this doctor being involved. Was he called by the court to investigate, or was he called by the hospital to investigate, or was he called by the family to investigate? Who introduced this doctor into this setting? Risotto. Is this a cheese petrified? I know this is it's a squirrel moment. Last night I was out. We took our 2 kids to a little youth activity, and it was a ways away, so we ended up staying with them because it would be quicker to stay there than to drive back home, then drive back and get them. And we stopped at a little Mexican restaurant that did mostly ice cream, and I didn't want something cold, and I asked if they had anything hot, and they asked for nachos, and they were out of nachos. And then they served something.
Is that correct?
Gelato. I don't know what it was. But it's basically steamed corn with mayonnaise, some sort of cheese that was like Parmesan, grated Parmesan, and chili powder. And I fell in love right then and there. It was so delicious. It was so good. I never would have thought. But anyway, this is, here we go. The doctor, Jill, I'm going to replace your message with who's going to be on the stand here as soon as we start. But the doctor... Pradeep Chopra, who is a double doctor. He's got his doctorate degree twice. Incredible guy. Not just incredibly smart. Okay, he said it was the court. So this is what stuck out. He was a little bit fuzzy on exactly who. He said it was somebody from the legal profession, and it might have been Briada's lawyer or someone from the court. But either way, just basically he's viewed Maya as an impartial doctor and came to these conclusions, and all his conclusions look very bad on Johns Hopkins. So it's going to be interesting. Spicy recross here as they try to regain some ground. Okay. Is he a paid expert witness? I don't know if he's paid. I imagine he probably is.
What more do you need to see?
What more do you need to see? The court originally called him as an expert witness, possibly paid. I mean, the judge doesn't call someone. Would it be CPS that got involved, or was this the CPS court that called this to try to settle this? There's some details that I'm just a little fuzzy on.
He's the guy.
It's a popular corn dish. I've had chili corn dip. It's pretty good. I just ate it with a spoon. I didn't know Mexican street corn. I didn't know they gave me a spoon.
I'm banking nice messages for next time I offend, face rolling on the floor laughing.
This is like buying indulgences, Ivan. When you pay the priest in advance and you say, I'll repent later because I haven't quite sinned yet. But it's coming. We'll watch for it. Thanks, Ivan. Appreciate that. It was very good. This is the tip jar doctor. Yes, he's made like $3-4 now in tips because he keeps getting interrupted, which, I mean, he's joking about it, but honestly, he gets thrown off his track so easily as he's making a presentation, and even the fact that the plaintiff attorney was rustling the papers and just shuffling. He's like pausing and looking. It's like, excuse me, I'm answering your question. What's going on here? He's like, oh, I'm just looking for this next thing. And he's like, well, do you want me to continue? So the defense lawyer has not yet learned that he is very distracting to the process with all the papers right there by that microphone. He does charge $1,000 for a first appointment for new patients, so no insurance for the first visit allowed. And he sees 5 new patients a week with CRPS, according to his testimony. Wonder how they're going to approach this doctor. This will be interesting, Tasha Turtle, because the doctor, he's such a kind guy. He's such a nice guy. I think his personality, him being nice, him being kind, him having that sort of bedside, friendly bedside manner is going to show through to when the defense is questioning him. So if defense comes out swinging and just attacking, and he responds in kindness, what does that do with the jury? Where does that put them? Does the jury feel like they're being attacked because they're with this guy on the stand, this witness who just is so believable and seems so smart and just so kind? The latte, I don't know. Somebody has to tell me here something about it, but it's crazy. Let's see. Live. I need to make sure we've got another feed going right here. Hold tight. It should be coming up any moment now. And it's not. My phone was ringing, though. Hang on one second. Hey, this is Recovery Addict. Oh, hey, Amber. How are you doing?
Hey. I wanted to call you to give some back information. I started to type it in chat, but it's too long for one chat message. So okay.
Scratch all that.
Dr. Chopra was brought in. The court would not fully release Maya to Jack after Beata passed away until Maya was fully evaluated by a CRPS specialist. Prior to Beata passing, she had communicated wanting to have Maya evaluated by Dr. Chopra, who specialized in CRPS, because the court wasn't acknowledging and accepting Dr. Kirkpatrick because he wasn't certified in pain management CRPS treatment. So Beata had started she started that name drop with her attorney.
Mm-hmm. And they're going to present that letter, that email where she says we need this, correct. We want this doctor. That will
correct.
Come up and cross
but
first.
It wasn't necessarily their initial. They're instigating that or initializing that point of treatment. It was the court would not fully release.
They raised this as, hey, here's an expert you can go to. This wasn't their inside man. It was an outside person, and they just presented the name.
Right.
And the court ordered it.
And okay. Right. And after Beata passed away, they conditionally released Maya to Jack's custody, but limited what she was allowed to be treated with, and until she was seen and evaluated by a specialist in CRPS with the appropriate credentials, which is when she went to Rhode Island to see Dr. Chopra, until she was then evaluated and he provided a report, would she then be released to Dad after Beata passed away?
Okay. That makes more sense. So they're gonna try to make it look like this was Beata's
idea.
Yeah, this was all her that orchestrated this, and she had this plan that he was going to say this, and sort of inside man type thing. And I don't think that's going to fly if what you've said is true, that which I believe is accurate. You've done a lot of research on this.
From my understanding, that's how this happened. It was already brought up that she would have to have an evaluation from a designated specialist of CRPS.
Yeah.
And Beata had already done her research on several providers, and she said, I can even take her to this designated, physician.
Yeah.
So it wasn't necessarily her bringing this up and initiating it. It was the
fact that she had done the research and found the best in the field,
right,
and said, how about this guy? Sounds good. I'm waiting. I can't wait to see how the defense spins this, because I know they're going to try to put a slant on that to make the jury think that, this was an inside job, and sort of they got railroaded on this one. But we'll see how it.
Lots of wow moments.
Yeah.
Lots of wow moments.
Yeah, Amber, you sound a lot better too. You sound like you're feeling a lot better. Is it?
I'm getting there.
Wonderful.
I think I'm on the upside of things finally, and I think the rest of the house is too. I still sound like crap, but feeling wise,
at least when there's a light at the end of the tunnel, So
I think so.
I think so. That's wonderful. Amber, thank you for the insight. Appreciate that clarification. You're right. That was way too long to type into a message. Thank you. We'll catch you later.
No problem.
All right.
Bye.
Bye. All right. Robert says, I just got home. Can you give me a quick rundown of what happened today? Today we've had a testimony from a pain management doctor as well as a physical therapist who treated Maya. The pain management doctor is one that was court-ordered, as Amber was just talking about, and it was the most bombshell type stuff. But the physical therapist did well as well. Oh, hang on, I think. Yep, judge is back. I'll make sure we've got some audio here. It's basically two medical professionals in a row that have basically said the hospital screwed up, and she was worse after treatment than before, and with the hospital. And the second one really just blamed it on the hospital and said, I believe the hospital is responsible for some of her condition, what happened. So buckle up. Here we go. It's going to be great. We've got a few minutes of business before the jury comes in. Jury comes in about 7 minutes. I've followed the judge's lead, and I'm not shaving.
Coming.
But he's got me beat by a few days.
Oh, I'm sorry, Judge. I'm here. That's okay.
Like I didn't see you there, Judge.
I don't want to interrupt. I just kind of figure out.
Judge, can you flip it on? I want to show you. I messed up. When we were having that colloquy there, I should have remembered the report. The report lays out an entire life care plan over the course of 2 pages, and I wanted to show it to you if you don't mind.
Did Maya change her shirt over lunch? Was that different attire?
So, if you go up here.
You just highlight it, the area.
Yes. Next page. Okay, beginning with considering the complexity of the condition.
Well,
down.
I need to turn it off and turn it back on so the gallery comes back on.
Okay.
I for whatever reason, sometimes those gallery TVs just don't like.
Yep. The judge with his IT expertise, turn it off and on again. That usually fixes the problem, and it does.
There we go.
And then on down from there, continue down, highlighting to the bottom, and then the start of the next page, please.
Same shirt. I just didn't pay attention.
Doctor, can I actually ask you to step outside for just a couple moments? Sure. Thank you, sir.
Doctor just got kicked out. He's one of the witnesses. Oh, he is the witness. That's right.
No, I'm just waiting for the doctor to get out of our presence. The transcript will reflect the doctor's out of our presence at this time.
At this time, Your Honor, I would like to continue direct examination. For the record, when we had a colloquy about the scope of the doctor's opinion, I had focused on the deposition, completely forgot about his report, which is Exhibit 2005-1 through 32.
They're going to object to that.
21. And in that, there is not a life care plan, but all of his recommendations to a reasonable medical probability of the care and treatment for Maya Kowalski based on her symptoms and his diagnosis. If you go to the next page, please.
Sorry, Robin, thank you very much. Welcome to the gallery. Good to have you here as a member.
So there he goes on. Also demonstrated positive results of physical therapy. Treatment with Dr. Hanna specializes. Basis for diagnosis, much of it is incorrect. She does not meet the criteria. I don't need that, but from that point up, and then the page before.
Mr. Anderson, I looked at it. Let me hear from Mr. Shapiro.
Yes, sir.
I guess I don't know what they're intending to do if Mr. Anderson wants to continue to correct on your objection. The basis for just to be clear, this is a plan that he had for Maya after one visit on January 22nd, 2017. If the question to him is simply, did you have a plan for Maya's care, you can walk through it, but that's different than saying, as a result of the mistreatment that you allege at All Children's Hospital, do you believe within a reasonable degree of medical probability she has these future problems? That was the basis of my objection because, again, in his deposition, I believe, clearly disavowed any future care opinions because he hadn't seen her. But I don't object if he just wants to continue his direct and ask him about what his plan for the patient was on that day based on.
He'll get to continue his direct.
Well, my recollection of the questions that were asked that we had the sidebar conversations on, or multiple sidebar conversations on, and my sustaining your objections, the concept was that it was an undisclosed opinion, that neither in his report nor in the deposition was there discussion of future, whether it was care and treatment or a future opinion. But this report suggests that he did, in fact, have opinions about future care. And so at this point, I'm going to reverse my rulings, and I will allow the questions that Mr. Anderson had previously asked, to which I sustained. And the plaintiff can continue in direct when we are in front of the jury.
Thank you, Your Honor.
Do you mind if I just get a quick point of clarification, respectfully, Your Honor? And I don't know if plaintiff intends to do this. Does this court find that merely because Dr. Chopra had a plan on this date for several things that he wanted and that his patient undergo, that would open the door for him to then talk about life care plans in the future as a result of negligence, or just merely that he can discuss what his plan is?
What I was just seeing on the screen was talking about future items. So, certainly I don't know what the doctor is going to say about future items. If it's beyond this, maybe that's going to be an issue. Yeah. But it's clear that he had a forward-looking report that was presumably available to the defense. And as such, I think it's fair game at this point. And that was the basis of my objection, was it was undisclosed, but it seems like it was, at least in part, if not in totally, available to the defense, and understood that that's what this doctor was going to be saying.
And just a last point of clarification, respectfully, the objection the defense is making is any testimony about future care related to future damages, as opposed to, and I don't have an objection to him talking about in his report his future plan of care for the patient. I think those are two different separate categories. Mr. Anderson may not be going back there, but I will make the contemporaneous objection.
I think you need to make the contemporaneous objection, and it may be that it is beyond his deposition and his report, but I think I need to actually hear the specific question at that particular point in time in the specific objection.
Switch feeds here
Are there any other issues we need to address?
so I can get the resolution a little better.
Your Honor, we had done a request for judicial notice, which the court granted on Trial Exhibit 2302-1 and 2301.
What is 23?
And those are, I've got copies real quick.
Can you just put it up so I know what you're talking about?
Put it up.
Give me a second here.
My intention, these are House resolutions regarding reflex sympathetic dystrophy month, and there was one in 2004.
What are you trying to do with a legislative resolution?
I am asking the witness to identify this and asking whether this is further evidence that the doctors at Johns Hopkins should have been aware of the problem of misdiagnosing exactly what they were diagnosing.
I'm unclear. You're asking a doctor from Rhode Island to comment on a resolution by the Florida House of Representatives?
Well, he is licensed in Florida as well, and it's a relatively minor point, but I think it is.
Has he been in the Florida legislature?
Not that I'm not aware of.
My recollection when I handled this before was I'll take judicial notice of it, but as a matter of evidentiary fact, that me taking judicial notice does not make it an evidentiary fact. I think is how I ruled, I don't know, 2 or 3 months ago.
I agree with that. I think that's what you said.
And I don't see this witness being able to talk to us about what the Florida House of Representatives has done.
I'll save it for cross or something else, and I'll bring it up again.
Anything else before we bring in the doctor?
Not from the plaintiff.
Not from the defense law.
Let's go get Dr. Chopra, please.
Okay, so I don't know exactly what just happened there, but what happened was the judge reversed a decision on a previous objection to questions that the plaintiff wanted to ask. They had sustained the objection, so now the plaintiff gets to go into an area of questioning with this witness that he wasn't able to before, and he also got to withdraw the your witness part where he turned the witness over to the defense. He gets to continue, so he's going to continue doing the questioning as if he had not turned it over yet, and he gets to go into something that he forgot.
Okay,
so yeah, that's a little
back, Doctor.
A little crazy, but we'll
just
see where
let you
this
know
goes.
when we bring the jury back in, since we've had this break, I'm going to remind you that you're under oath. I'm going to do that in front of the jury.
Sure.
Okay, just to let you know, I'm going to do that. Sure. Let's bring in the jury.
Yes, sir.
All right, this is good stuff. Has he been in the Florida legislature? Not that I'm aware of. Yeah, he's asking him to comment on a rule, a law, and I think they could have done a better argument of that before the judge and saying actually this is a law that the doctors are required to follow and it's very pertinent to their operation. They're very familiar with it, and he could comment to it from that angle. But as far as like from a legislative position, he's the wrong person.
Hey, everyone, please be seated. Okay, members of the jury, I want to confirm while you were away, you did not discuss this case amongst yourselves, you did not do any investigation, and you received no information. Is that correct? Yes. I also want to confirm that and ensure that no one approached you about this case since we last were together. Is that correct? And that you have not seen any media coverage about this case since the last time we were together. Is that correct? Correct. Thank you very much. Mr. Anderson, you may continue your questioning, sir.
I'm not sure if Maya's in pain or just uncomfortable with this, reliving this, but her breathing has been
I'm back.
A little bit faster than I would expect.
Sticky too.
Before we broke, there was a series of questions concerning Maya's future care. And I'm allowed now to ask you about them, and I want to reference you to your report of January 22nd, 2017. And with the court's permission, I have it published here. Previously discussed it. Can you go through this? You don't have to dwell on every one of them, but I want you to name off for the jury here the various treatments and the reason why they are reasonably medically necessary for Maya, given her aggravation from CRPS.
Same objection, Your Honor.
So, one of the things about treating CRPS is that I do is I know the definition is everything else has been ruled out.
Seriously, with the papers?
The patient has severe excruciating pain and everything else has been ruled out by definition. That's the definition of CRPS. But I still look for a cause. Maybe there is something somebody missed, or there is something that I can find, and that would be obviously magical, because then if you know what's broken, we can fix it. So in her case, I looked for a condition called Ehlers-Danlos syndrome, or in brief, EDS. It's a kind of a benign condition where your joints are loose, you're hypermobile, and she had some features of that. Now, I wasn't sure about it because at that time, this was back then, there were no guidelines on how to diagnose this condition. It was actually in 2017, later on, that the guidelines came out on how to diagnose it. So I just put that there, that later on in the future in her life, she might ever want to explore that, she can do that.
Next one. See, when she's shown on the screen for extended periods of time, I'm able to see her.
The next one was
shoulders rise and
I
fall
said
with her
that she
breaths.
meets the criteria for complex regional pain syndrome.
And then let's go to 3, as I think we've covered that.
So in number 3, I talked about a condition called tethered cord syndrome. And this is actually a condition common in children, and it is common in patients with Ehlers-Danlos syndrome. And in this case, what happens is that these patients have, their spinal cord is not hanging loose in their spine. It's tethered to the bottom of their spine. And it's a congenital condition, and oftentimes these patients can present with pain in both their legs. And it's a neurological condition, and it is diagnosed by a neurosurgeon. I also put that in there because maybe she has it, maybe we need to do a further workup, we don't know.
Okay, can we go to the next one then? 4.
Are we going to magnify?
Let's see. 1, 4. I don't need to cover
Okay.
that one. I was really interested in the CRPS treatment on the next page. Okay. Now, beginning in number 5, if you could go down and let me ask you the question. From 5 down through, I think then there's more on the next page. But these from 5 on down, are these reasonable and necessary medical condition treatments for Maya Kowalski based on the aggravation of her CRPS to a reasonable medical probability?
Yes, these are reasonably necessary, absolutely.
So let's give the jury an idea here of, we've talked about things that she can look into in case, but let's talk about what you think she should be doing or the treatment she should have.
Based on my...
Your report, which
okay,
is in evidence.
so on number 5, I put in there, recommend physical therapy for upper body strengthening exercises. So here's the thing. When she got her initial ketamine at Dr. Kirkpatrick's office, her upper body pain actually improved. The pain in her arms improved, but not the pain in the legs. And so, she was, when people use a walker, they need upper body strength because that's what they're supporting themselves on. They need to have stronger arms, stronger upper body. And so I said, all right, let's strengthen what we can strengthen. and at least so she can, hold the walker and walk. So that's what I said.
And how much, as she continues in life, should she reasonably expect to attend or go to a reasonable medical probability in order to minimize the effects of the aggravated CRPS?
Well, to minimize she has to completely avoid aggravating her CRPS.
Let's assume in life there is aggravations now and again. How is the physical therapy, should it be periodic, or should she continue to attend physical therapy throughout her life so long as she has the symptoms to a reasonable medical probability?
I need to clarify that.
Sure.
I actually said to hold off physical therapy for her legs.
Right.
Because you cannot do physical therapy on someone who has excruciating pain in their legs.
Right.
Okay, that's it. So for now, just strengthen the upper body, control the rest of her pain in her legs, which had been aggravated by her whole episode at the ACH, and then work on the legs.
Okay. As she has, and to a reasonable medical probability, is Maya going to have relapses from time to time of varying degrees and types?
Yes, she is. Okay, let's talk about the relapses for a second. This is not a joke. We're not talking about a relapse of a little headache. We are talking about severe. She lives at a baseline pain that you and I cannot even comprehend. Okay, that's baseline pain. Her brain has now changed enough that she is okay with that pain. When she has an exacerbation, it's horrible.
And are you aware, or has it come to your attention, that she has in fact had a relapse in November of 2020 that put her in the hospital?
Yes, I know that she did, and I don't know what happened. It may have been some sort of a stress. I know she didn't have an accident or a physical fall, but it could have been some stressful event that could have triggered that.
And her already having had a relapse some, 2.5 years, 3 years after getting out of Johns Hopkins, does that have an effect on your opinion that she may have more and longer and more aggravated relapses through her life?
Same objection.
You can answer.
It's the same, it's the same analogy I gave you. If you have a wound on your arm and before it heals, you whack it and it breaks down, the skin breaks down again and the wound becomes worse again. And if you keep continuing doing that, one day it's never going to heal. One day you're going to be left with a really terrible open wound on your hand. And that's the same thing with this. If you keep aggravating her CRPS, her brain is finally going to alter itself. If it hasn't done it now, it is finally going to alter itself. That is that her CRPS will never ever go away. It never goes away. It gets we use the word remission, where it kind of comes down a little bit, enough that they can function.
And I believe you testified to this before, but just to tie it in, do you have an opinion based upon your background, training, and experience, and to a reasonable medical probability, if whether the timing and the intensity of what she experienced at Johns Hopkins over those 3.5 months aggravated that CRPS so as to cause her extra injury and damage?
Same objection.
Overruled. You can answer.
So, I need to give you the bigger picture on this.
They need a yes or no.
Okay, go ahead. I just wanted to, yes, you do have an opinion or no?
You need to add $2 there. So,
at $2.
I got to make money today. So here we are, so we have a 10-year-old girl and she's got CRPS in her legs, okay? But Her mom's frantically running around all over the country from Chicago to Tampa looking for treatment for her. Okay, she finally finds Dr. Kirkpatrick. He does ketamine on her. It helps her partially. It helps her arms. Okay, we got a little win there. But then he says, look, you need much more than what I can give you. So you need to go to Mexico and see Dr. Cantu, who's going to give you a ton of ketamine. And she does. And she comes back and she does well. Mm-hmm. And in fact, she does so well that Dr. Who's the doctor from?
Hannah or?
No, there's a doctor
Cantu?
from Johns Hopkins, a pulmonologist.
Oh, Kreisman. Dr. Kreisman.
Dr. Kreisman and her pediatrician said, this is not the same girl. This is a different girl. Her skin lesions were gone. She was a whole different girl. They both commented on that. And then, obviously, you can't afford treatment in Mexico that long. It's expensive. So she did the next best thing was to go to Dr. Hannah, who tends to use higher doses. And so it was some sort of an agreement that she made. And she started to do ketamine with Dr. Hannah at somewhat higher doses, and she was doing great. There are videos of her swimming, running around, playing, doing great with physical therapy after Dr. Hannah's treatment. So you can see the progression that from a lower dose with Dr. Kirkpatrick to a higher dose to Dr. Cantu and then to Dr. Hannah, she is starting to make progress. Now she has this abdominal pain, goes to Johns Hopkins, and then everything goes down the drain. They don't believe her, they don't treat her stomach pain, they don't take care of her CRPS, they don't even, and she's been there dozens of times before, and now they treat her like they've never seen her before, they don't believe her, they stop all her treatments, and not only that, they mistreat her by keep touching her, keep handling her, and her CRPS flares up back to where it was.
So is that a yes? Johns Hopkins did aggravate her CRPS so as to cause her more damage and injury in the future?
Yes, very much.
And so let's continue down here. You've had, exercise and joint protection. I think you've talked about, avoid desensitization. Avoid desensitization,
of a lot of these
sensitization exercises. What's that about?
So, one of the theories in CRPS is that, all right, if because your arm is so sensitive, I'm just taking the arm. If your arm is so sensitive and if you have CRPS there and touching it makes it painful, we are going to touch it even more. We'll take a rough towel or a sponge or something like that and rub it even more so that your brain gets used to it. Okay, now that philosophy is actually counterproductive because do you remember how I said this morning that a barrage of pain signals, if I took a pen and I stuck it in my finger again and again, there would be a barrage of pain signals to my brain. And then the brain then alters itself. And it now takes over the pain. And this is what will happen when you do so-called desensitization exercises. If I take a rough towel and I start rubbing it on the area of CRPS, you are sending even more signals up there. There is zero literature. I am not kidding you. There is zero literature on the benefits of desensitization. I have searched it everywhere. I've asked people who do this. I said, where did you learn this from? Where is it? No one knows. So,
Doctor, why don't we wait for the next question and then you can answer?
You owe me $1 back.
Oh, sorry.
You owe me $1 back, he says.
No. The question then is,
they might.
Can you describe for the jury then with more specificity, is she going to have more of these relapses than she would have had she not been interrupted in her first round of care?
Yes.
Will they be more aggravated when she has them? That means more painful, more debilitating. And third, will they be, in terms of length, longer? So the three, again, are, she's going to have more, number.
How about one question at a time?
Yes, sir. You get my question?
Yes, to answer your question, yes, she'll have more frequent incidences of CRPS because the treatment that was initially working for her was interrupted.
And will those episodes be longer in length than they would have been, or will have any effect on that?
That's a slightly difficult question to answer.
Fair
Some
enough.
will be longer and some may not be that long.
But can you tell us when she does have them, are they going to be more intense than they would have been had she completed the therapies that were in place?
Yes, every exacerbation she's going to have is going to be a lot more intense.
So she's going to have a
That
lot
puts the blame
more
on the
and
hospital.
more intense, but there's no way to tell the length of them.
Sustained
It's just a summation. Okay. Now, well, we haven't finished this. Doctor, I don't want to take a whole lot of time because it's in the report, which is in evidence, and so you can read it. They can read it for themselves. But generally speaking, can you tell me? Can you tell us? I'm going to stick a step ahead here to number 10, gastroenterology, and why that's important.
So when I talked to her, and I went through every system, and when I got to the stomach, and I asked her, "Do you get bloating when you eat?" And she said, "Yes, absolutely, I do get bloating when I eat small amounts of food." And remember, she had already been to Johns Hopkins twice. I think, as long as I remember, it was twice for belly pain. And what happens as a complication of CRPS is the nervous system that controls the movement of your intestines. So your intestines move like a toothpaste, okay? So when you eat food, it moves along like a toothpaste. And that is controlled by a nervous system called the sympathetic nervous system. And that is affected in CRPS. And that was the reason her food was not moving, and obviously it was collecting, and she was
I'm
starting
going to
have
object to him
all this
saying you squeeze
abdominal
both
pain,
ends of the
belly pain.
toothpaste tube, because that is just
And
wrong.
she was getting malnutrition because of it.
All right. Then is there a number 12 there, or have we reached the end? It says under 11A, it was minimized trauma. I think you've covered that. And then we go on the next page to continue on to the top, please. I think there's more. Go up. Here. Vitamin C exercise program, trial of graded motor imagery. What is that?
So there was a research that came out of Australia. It's actually accepted research modality for treatment of CRPS.
Sustain that objection.
What was the objection?
Bolstering.
Oh, okay. Just tell us what graded motor imagery is, the basics.
It's in 3 parts, and the 3 parts are mentioned over there. It's a kind of an exercise you can do at home for people who have CRPS in one limb.
And then you said an echocardiogram. Is that periodic under number 12?
That's if she has Ehlers-Danlos syndrome, then an echocardiogram is a standard practice.
All right. And then, okay, positive results of physical therapy. So should she keep up physical therapy throughout her life as she's done?
Provided her pain is controlled.
Right. What about medications? Do you have an opinion based upon your background, training, experience, or reasonable medical probability if from time to time she would benefit from medication?
That's a difficult question to answer because her mother had tried a lot of medications, but that was a different time, and so we don't know if she can try them again. But she will need to try different medicines.
And with based on the assumption that the relapse occurred some 2.5 years after she got out of Johns Hopkins, do you have an opinion to a reasonable medical probability that the opinions you have offered here are equally applicable for this jury today?
Can you rephrase that?
That wasn't a very good question. To a reasonable medical probability, is your report here in 2017 applicable today, these different treatments and future medical care?
Yes.
So, just a couple last questions. I think the jury will hear at some point about intrathecal pumps and Beata Kowalski's request, or just asking about it in theory. But what is an intrathecal pump, and is this some boogeyman that we should be afraid of?
Object to the compound.
All right.
Why don't we just go, what is the pump?
Yeah,
What
no
is the pump?
boogeyman, sorry.
No boogeyman.
Intrathecal pump simply means a pump in the spine. So the principle is actually amazing. And I'll give you an example. If a person needs, say, 10 milligram, needs morphine, 10 milligram pill for their pain by mouth, 10 milligrams by mouth. If you give the same morphine into their spine, they'll only need 1 milligram, which means they need lower doses. It is far more effective because you're hitting the pain at the source, and you're also not seeing any side effects. So intrathecal is in straight language, it means spinal pump.
And from your experience with mothers and fathers of children with this extreme pain, do you find it in any way unusual or odd that she would question whether the intrathecal pump would be appropriate for Maya?
Yes, it is an appropriate request. I thought it was an amazing request that she made it, because she's trying to decrease the dose of drugs that Maya is getting.
Mm-hmm. All right. And finally, is ketamine FDA approved for children?
Yes, it's used all the time for children.
And is it now FDA approved as what's known as an orphan drug?
Yes, it is.
And what is an orphan drug?
So actually the sentence should be, is it approved as an orphan drug for CRPS?
For our CRPS, my apologies.
Yes. And so, there are some diseases that, like the FDA has these rules, okay? Like they might say, somebody with migraines, we need, a million patients. We need you to test this drug on 1 million patients.
Object to the hearsay on the FDA rules.
Well, I'm just trying to explain.
You can answer that one.
You can answer.
But in some diseases that are not that common, they can't get 1 million patients with CRPS. So the FDA says, all right, we'll let you do it with 400 patients. And that's called an orphan drug use. So they kind of make it, they're not all diseases are that common, and some diseases that are not common, they put them down as orphan drug use.
Is that because of the expense of doing a full trials?
No, it's because they can't find that many people.
Okay. And I have to ask you one last question on liability here. And do you have an opinion based upon your background, training, and experience into a reasonable medical probability from everything you've seen here, whether the doctors comprising the Johns Hopkins pain management team, that is Laura Vos, Richard Elliott, Amish Patel, and nurse Ashley Sumner, breached a duty of reasonable care by deviating from the accepted standard of care insofar as the care and treatment of Maya Kowalski?
Yes.
Overruled. The answer stands.
And can you tell us, to a reasonable degree of medical probability based upon your background, training, and experience, whether that was a cause of this aggravation and this future we now know about for Maya?
Can you explain that a little bit more?
Sure. I want to know whether, when you answered about they breached a duty of reasonable care, was that breach a cause of the damage and injury to Maya?
Yes, it was.
And is that to a reasonable medical probability?
Yes.
Your witness?
There it was. Ended with a huge 1-2 punch. See how they handled this.
Good afternoon.
Good afternoon.
A celebratory drinking on the plaintiff's side, I guess. I don't know. With water.
Were you aware that Beata Kowalski chose you?
No, I had no idea.
First time you're learning about that today?
This is the first time I'm hearing this.
Okay. You're not an emergency physician, correct?
No.
You're not board certified in pediatric anesthesiology either.
No.
You, in terms of hospital privileges, you haven't had any in more than 20 years, right?
I chose not to.
Okay. You don't treat patients in hospitals.
I don't have the time to go to hospital.
Okay. In terms of your fees to be here, what are you charging?
Sorry, could you?
What do you charge to be here?
Oh, so far, they've been kind enough to pay for my hotel. The rest, I have no idea.
Okay. You haven't sent a bill to Mr. Anderson yet for your time?
No, I haven't.
Okay. Do you know what it will be, or you haven't tallied it?
I have no idea. My office handles that. I don't handle that.
Okay. I know you don't know the amount, but just so it's clear, Mr. Anderson, his office is paying you to be here today and for your review. Is that fair?
They're paying for my time.
Okay. Let me ask you about ketamine. You told the jury a moment ago about FDA approval. Back when
One of the
Maya
best
was
answers
getting
to that question we've heard.
In 2017, ketamine was not approved by the FDA for CRPS. True?
Well, yes.
That's true.
That's true.
Okay. I want to talk to you a little bit about your statement that Maya was improving before she went to All Children's in October of 2017. You base that on your review of Dr. Hana's records, right?
Actually, I based that not just on his records, but also on videos.
Okay. Well, let me see if I can narrow down a time frame here. Clay, will you put up what's in evidence as Joint Exhibit 1040-206? And you can enlarge this. I will represent to you, we can go to, this is a signed letter from Dr. Hana dated September 25th, 2016. Do you see that?
Yes.
I'll represent to you that this was written by Dr. Hana to the school district to explain homebound status. And I'm going to ask you about some of the statements in here to see if this is consistent with what you're telling the jury in terms of how Maya was actually doing before she went to my client's hospital. At the top it says, Maya suffers from horrific disease, RSD, CRPS. Do you see that?
Yes.
Your testimony to this jury is before Maya ever went to my client's hospital, she had debilitating CRPS. That's what you believe, correct?
Yes.
And as a result of her debilitating, horrible CRPS, she was going to require, in your mind, a lifetime of care. True?
Yes.
Okay. Now, reading down on this, it says on September 6, 2016, evening time, Maya had a relapse of her RSD. Maya became overstressed, extremely worried, and crying after a September 6, 2016 individual education plan meeting at Taylor Ranch School, which I strongly believe led to her RSD relapse. Do you see that?
Yes.
Okay. Did you know, and maybe you didn't, but did you know what caused this alleged relapse of RSD?
Well, it says right here.
Okay.
After the IEP meeting.
So, at least from your understanding reading this record, there was a psychological stress on Maya that you would attribute to the relapse of RSD. Is that fair?
A stressful event at the IEP meeting.
According to this letter, Maya was then complaining of severe pain to her legs, 10 out of 10. True?
True.
She was complaining of severe pain to her back, 10 out of 10. True?
True.
She was complaining of severe pain to her arms, 9 out of 10. True?
True.
Severe pain to her stomach, 9 out of 10. True?
True.
Migraine pain, 10 out of 10. Correct?
Correct.
Severe weakness, nausea, and vomiting, and was unable to eat or drink fluids for 3.5 days, leading to her dehydration. True?
True.
And all of that was a couple weeks before she entered Johns Hopkins Children's Hospital on October 6th, correct? October 7th, I apologize.
Yes.
Meaning this was her condition. And in addition, because you were telling the jury how well she was doing, I want to make sure that you understand this letter. Maya also required daily IV fluids for hydration leading up to her hospitalization at All Children's. True?
Well, this needs clarification. You can't just say true.
Well, do you have any reason to dispute what Dr. Hanna wrote to the school board saying that starting on September 6, 2016, Maya, on a letter dated September 25th, so now 3 weeks later, that Maya was requiring IV fluids for hydration? Do you have any reason to dispute this?
No, I have reason to dispute a lot of this letter because, you see, she was doing well, and then she had this IEP meeting on 9/6/16, and obviously that was a stressful meeting, and she went down. Everything, her condition got worse. Now that's a feature of CRPS.
But my point, doctor, is she never got better between this September 9th, 2016 relapse that you're claiming is a relapse of CRPS until she went to All Children's on October 7th. You recognize that, right?
No, I don't. How do you know that she didn't get better?
All right, let me show you the next record. Well, before we move on to this, the second last sentence says, as of September 15th, 2016, Maya K's RSD relapsed, and she has not returned to her usual baseline where she used to be prior. Do you see that?
When she used to be prior to 9/6/16. Okay, yeah, I do see that.
Okay, so now let me ask you about what's Joint Exhibit 1040-20. This is in evidence.
We should see
Dr.
both
Hanna's
tables,
records.
both the plaintiff and defense, all the time.
Joint Exhibit 1040/20. And if you can zoom into the top on the date, this is October 5th. So now, if you want to clarify whether Maya was better before she walked into the hospital, I'll represent to you, this is now 2 days before Dr. Hanna asked her to be admitted to All Children's. So let's scroll down a little bit more. Do you see on the history of present illness in capital letters, patient stated that her weekend was rough and she didn't sleep due to pain and had a great deal of nausea and vomiting. Do you see that?
Yes, I do see it.
And on the weight chart, 2 days before she went to All Children, she was 60 pounds. That's the 5th percentile. True?
She's tiny.
Yes.
And her height was below the 1st percentile. Do you see that?
Yes.
Do you know from your review of the records that Dr. Hanna then infused 1,250 milligrams of ketamine?
This was the day before she went to...
2 days before.
2 days before she went to All Children's.
Correct.
Yes, I know that.
Do you actually know that she underwent 5 ketamine infusions in the days leading up to going to All Children's?
Yes.
Okay. Let me ask you, Clay, if you'll turn to Joint Exhibit 1040/233. Were you aware that Dr. Hanna had his patient Maya fill out how she was feeling in her overall, what they call quality of life survey?
Okay, so I'm not just going to say yes to this.
Well, let me ask you this, and then if you need to explain, you can. You're aware of something called the American Chronic Pain Association Quality of Life Scale, correct?
Again, this is not an accepted quality of life scale.
Okay. Well,
this is by an association that doesn't mean anything.
Okay. Well, the question, you can see there's 0 through 10, where they're asking Maya, how are you feeling, with 10 being go to work, volunteer each day, normal daily activities each day, have a social life outside work, take on an active part of family life. That would be 10, normal. 0 is stay in bed all day, feel hopeless and helpless about life. Were you aware that 2 days before Maya went to All Children's, her function was 0, according to the survey? Were you aware of it?
Right, and that's expected of it. A 10-year-old child with excruciating pain everywhere is going to be, she doesn't see anything left in her life because she's in excruciating pain all the time.
Let me ask you about Joint Exhibit 1040/17. Were you aware that even after this, Maya went back to Dr. Hanna the next day for a large IV ketamine infusion? Were you aware of it?
Which date is that?
This is October 6, 2016, the day before she was admitted to All Children's. Were you aware she was up in Clearwater getting a ketamine infusion from Dr. Hanna?
Well, I do see the record, so I'm sure she did.
Okay. And in fact, at least the time of the record is 3:40 p.m. I'll represent to you she was admitted to All Children's the next morning. But according to the record, again, it says on the history and physical, patient and mother state patient is still in extreme pain. Do you see that?
Yes.
And then, Clay, I'll ask you to go to Joint Exhibit 1040/225. This is the quality of life survey filled out the day before she went to All Children's. It was 0 again, wasn't it, doctor?
That 0 is going to be there for a long, long time.
You expected this 0 to be there for months, didn't you?
Listen, if you have the world's worst excruciating pain and you're a 10-year-old kid, let alone if you had it in one leg, you would be still 0. She had it in 4 limbs. She is always going to mark that 0 at that point.
But certainly what you're telling this jury, it sounds like, is based on her condition the day before All Children's, Maya was going to be sick with crippling pain for a while, correct?
She's going to be sick with crippling pain for most of her life.
Right, including through her hospitalization at All Children's. That's what you think. Not because of what All Children's did, because that's her condition. Correct?
Right, and she did not respond to the ketamine that given to her 2 days before that, and then she had abdominal pain. And that was the reason she went to All Children's.
Because the ketamine failed, correct? The ketamine...
That episode failed.
Okay, let me next ask you about some of the things that went on in the hospital. And before I do, let me just ask you this. You use ketamine. You do not, in your practice, recommend ketamine comas, true?
I don't do ketamine coma in my practice.
Okay. You don't do hyperbaric oxygen therapy?
No, I don't.
You don't do oral ketamine?
I do sublingual ketamine, which is under the tongue. You put this ketamine under the tongue. You don't swallow the pill.
You don't drink oral ketamine with Gatorade for your patients, do you? You don't have ketamine mixed with Gatorade and have the patient drink it at home, do you?
I don't believe in oral ketamine.
Okay. Let me ask you, before we move on to what happened in the hospital, you do recognize there is authoritative literature in the field of ketamine infusion, true?
Objection.
There is a what of literature?
Hold on a second, doctor. What's the legal basis?
Improper impeachment regarding literature.
Well, I'm asking him if he can, so I'll rephrase the question. For infusion of IV ketamine for CRPS, are you aware of consensus guidelines?
Yes.
And do you consider those guidelines authoritative in your field?
I'm sorry, consider what?
Do you consider those guidelines authoritative in your field?
No.
Okay. Do you remember when I took your deposition on February 25th, 2022? I'll hand you a copy. I'm going to ask you to turn to page 37. If I may approach it.
You may. Sure.
This is a copy of your deposition that I took.
Page 37?
Yes, page 37. And on line 15, I asked you, for the infusion of IV ketamine for CRPS, are you aware of any consensus guidelines? And your answer is yes, there is one. And I asked you, do you consider it authoritative in your field? You said yes. Well, it is authoritative.
Well, I wasn't referring to the one you're referring to. You're referring to Stephen Cohen's.
The one attached to your deposition. I asked you, was that authoritative? And we marked as Exhibit 9 to your deposition. Are you saying you no longer recognize it as authoritative?
What's attached to my deposition?
I'll hand you the article.
Huh?
We're talking about the one authored by Dr. Stephen Cohen, correct?
You're talking about that, not me.
Okay. When I showed you Stephen Cohen's article in your deposition, you told me it was authoritative per your testimony, did you not?
I don't recall seeing Stephen Cohen's, because I've never believed in those guidelines.
Okay. Well, let me ask you about some of the care that went on at All Children's. You were aware, well, let me just ask you about, you reviewed the records from All Children's, true?
Yeah, 7,000 pages.
Okay. Let me ask you about Joint Exhibit 1001-2718. At the bottom where it says result comments R46, the second paragraph, did you review this record? Patient also stated in the room with me that she hasn't eaten in 5 days. I asked her if she doesn't have an appetite, and she said she can't eat because she's not allowed. Did you review that record?
Listen, there were 7,000 pages, so I can't tell you whether I reviewed it or not. But I agree that if you're showing it to me and you tell me this is from them, yes.
Let me ask you about Joint Exhibit 1001-3746.
Objection, Your Honor. Improper impeachment. He's not reading the second sentence right there that explains it.
Overruled. You can continue.
That'll be on cross.
On Joint Exhibit 1001-3746, at the bottom, were you aware in reviewing the records that Mrs. Kowalski refused to have her child evaluated by psychiatry on admission? Were you aware of it?
Oh, yes, and I'm not surprised.
Okay. Were you also...
That's very appropriate.
Were you... So what you're telling this jury is you don't believe that Maya should have ever been assessed by a psychologist, true?
True, absolutely.
Okay, so let me ask you about her time in the hospital. Were you aware in reviewing the records that All Children's Hospital tried to transfer Maya to a comprehensive program for CRPS, but the parents refused?
Objection. No. There's no facts in evidence on any of that.
Okay, let me direct you to Joint Exhibit 1001-1765. Under projected discharge planning needs about halfway down, placement, and I'll represent to you this is November 10th, inpatient rehabilitation care, court order pending, parents declining to sign consent at this time. And then under provision of care, it says, mother continues to deny consent for inpatient treatment at Nemours. Were you aware of that?
What's the question?
My question is, you've been critical of the care Maya received at All Children's. All Children's was trying to transfer her to a comprehensive center for... He asked me to...
Evidence. None of these documents are in evidence.
This is the joint exhibit from All Children's.
Time out. Gentlemen, if you could approach.
Okay, this is getting spicy. The defense is doing a good job here. Look at the... Oh, my goodness. Look at the facial expressions. Everybody, anybody who's on camera right now, look at their facial expressions. Defense is doing a good job cross-examining and pulling details out of their records here. Details where the hospital has documented things that make them look better than what this doctor has testified regarding their care. Basically, this doctor says everything they did was wrong and caused the problems. Now we have the defense coming out and saying, well, here's what we tried to do, and the family wouldn't let us help. And we tried to do what you suggest, and the family would stand in the way. Now there's more to it than that. Okay, they're parsing things down to just a very little fact and trying to make it stand on its own. And there's a whole story around that, and they hopefully will be able to go into this. I need to count this objection, right? There we go, 149. We might hit 200 today. Anyway, so it's going to be interesting. The hospital is regaining some ground here. The doctor is doing a good job with still being friendly, still being, still coming across as truthful. But also he's doing a good job with his answers as letting the jury know that the way the defense is looking at it is with blinders and very narrowly, and it's a larger scope than that. You can't just say, doesn't this word say what I say it says? And you're like, well, yes, but that's not the whole story. So we're seeing he's doing a good job on the stand currently with that. Defense is not making any ground, says SF in Texas. The parents didn't sign consent maybe because they couldn't see or talk to their daughter before agreeing to transfer her. I don't know off the top of my head what the issue was, but it's signing consent, I believe, gave up something that they weren't okay with. And so it was not that they didn't want her to get treated. It's that other part they weren't okay.
Question is sustained, but you may continue, Mr. Shapiro.
Sustained, but you may continue.
Thank you.
Interesting.
Doctor, were you aware during Maya's hospitalization that the parents declined to have her transferred to another hospital for care?
But
were you aware of it?
Well, yes, according to what you're showing me on the document, yes. But I need to elaborate why they refused.
Okay. Well, you're welcome to when Mr. Anderson asks you questions.
Actually, you can answer.
Okay, go ahead.
Judge is like, actually, you can
Yeah.
now.
Go ahead.
Well, because the idea of treating CRPS is first you've got to control the pain. You can't have a patient with severe burning pain in 4 limbs and you put them into an inpatient rehab center and start making them exercise. So ACH was not doing anything to help her pain. And so they need to control her pain, and then they would have transferred her to any other place they could. She was doing rehab anyway. She was even doing rehab at ACH.
Are you telling this jury that in your review of all the All Children's records, they never offered Maya anything for pain?
Not enough.
They offered Maya pain medication during her hospitalization. You know that.
But they didn't control the pain.
You are aware that, or are you aware whether there were attempts to transfer her for outpatient therapy? Are you aware?
This doctor does not have rights.
Sorry, could you rephrase that question?
Are you aware of whether All Children's attempted to transfer or discharge Maya earlier in her hospitalization for outpatient therapy?
Well, I mean, you're not getting my point. My point is that All Children's did not control her pain. And now they're trying to pass her off to an inpatient rehab or an outpatient rehab or something like that. That's what they're doing. And the parents didn't want that. The parents wanted her pain controlled, and they would have done the rehab happily by themselves. They were doing it at Dr. Hanna's place.
And we talked about Dr. Palmer's records and their success rate, but let me ask you about your evaluation of mine in your report.
Good grief. I'll tell you why we're hearing all this noise. The microphone that's set up in front of this attorney is not the microphone that's picking up our sound.
The recommendations you made in your... Well, let me just back up. I apologize, doctor. You've seen Maya once for a forensic evaluation in January of 2017, correct?
Yes.
You have not evaluated her since, true?
No.
Okay. You sat with her for 5 hours and 22 minutes?
That's correct.
What pain medication did you give her for your evaluation?
No, it's just an evaluation, not a treatment.
Okay. She was able to tolerate your evaluation without any pain medication?
She wasn't. She was in severe pain.
She sat with you for 5 hours and 22 minutes, true?
She lay down. She didn't sit.
Let me ask you about some of your statements or plans of care. And actually, let me, I think this is Joint Exhibit 2005-1. Clay, if you don't mind putting it up on the screen, please. Well, I may have the wrong exhibit. There we go. I think this is what Mr. Anderson walked you through. True?
Yes, he did.
Okay. The way, and it's just technicality, but I thought it was important to point out, so let me just ask you. This report that you have was actually a letter back to her primary care pediatrician, Dr. Wassenaar, true?
Yes.
Did you ever speak with Dr. Wassenaar?
No.
Let me ask you about some of the recommendations in your report. By the way, at this point, Maya hadn't walked in almost 2 years, true?
I don't remember that.
Okay.
For how long she hadn't walked.
I'm not trying to trap you, I promise. The testimony that the jury's heard is generally that after about July 4th, 2015, she was in a wheelchair from that point going forward. And if I got that wrong, I'm sure someone's going to jump up and tell me. But all that being said, so now we're 2015, 2016, so about a year and a half, she has not been out of her wheelchair walking, okay? Would the lack of walking secondary to what you believe is CRPS cause her legs to be atrophied?
Yes.
Let me ask you about some of the recommendations that you were talking about with Mr. Anderson that begin, I think, on page 18. It could be 19. That's it. All of these recommendations are because Maya has CRPS, true?
No.
Well, I guess that's fair. Some of these are because you think she may have had Ehlers-Danlos syndrome, true?
Right.
That's a genetic disease.
Yes.
Did you test for it?
I did a clinical. There's no blood test for it. It's a clinical test.
Okay. Do you know if Dr. Wassenaar ever followed up on your letter to him recommending treatment for Ehlers-Danlos syndrome?
My job was very clear. The question I was asked was, does she have CRPS or not? And that was my job. My job was, I wasn't a treating physician.
I understand. You were serving as a forensic expert on this issue, true?
True.
Okay. But you did, in your evaluation of Maya, believe she may have had a genetic cause for some of her problems, true?
Could be.
And you also thought that she may have had a neurologic cause in the form of a tethered cord unrelated to CRPS?
I wasn't sure. I needed her to see a neurosurgeon to decide that.
Do you know if Dr. Wassenaar ever followed up with a neurosurgeon?
I don't know.
You also, in your report, if you go down a little bit on the same page, talked about bilateral thoracic outlet syndrome. Do you know if any follow-up was ever done for Maya regarding that?
We've already established that this was my one and only contact with Maya, and it is a forensic exam, so not the treating physician. I don't follow up.
Okay. Then I promise you I won't belabor the question. The answer to any question I ask you of, do you know if Dr. Wassenauer ever followed up with this, any of this, the answer would be you don't know.
No.
Okay.
I don't know.
And in terms of her complex regional pain syndrome number 11, it says minimize surgical trauma. At the bottom, 11A. Minimize surgical trauma, including needle sticks. Okay. It was your belief at that time that Maya's CRPS was so bad that for the going forward, she wouldn't be able to tolerate needle sticks. Is that true?
No, that's not what the recommendation means.
Okay, so and let me try to clarify. I appreciate that. In terms of what you're telling this jury, you don't know in the future whether Maya is going to have this problem because you haven't evaluated her. True?
We know she has CRPS. So this rule applies to her for the rest of her life. So a person can have CRPS in their left leg and they still are at risk if they get a needle stick in their right arm.
Piercings, she'd be at risk if she got piercings.
That is the risk.
Okay, do you know if Maya ever got piercings?
No, I don't know.
Do you know if she got piercings, whether she had any pain from them?
I don't know.
Okay. Do you know if she's had any subsequent surgeries where she's had any problems as a result of surgery, or you don't know?
So that's not how the human body works. So if you have CRPS and you get a piercing or you get a surgery, the chance of your CRPS getting worse or spreading is high, but doesn't mean that it will get high or it will spread.
So what you're telling this jury, you're not saying that these things on her list are more likely than not to happen. You're just saying that these things on your list are things that somebody, for example, with CRPS might encounter. Is that fair?
Just vague. Overruled 14 of them.
It's a standard recommendation for any patient with CRPS.
Got it. The recommendations on here are standard for anyone who has this diagnosis, true?
Recommendation 11A.
Okay. The just a couple more questions, Doc. Well, let me ask you a little bit about, you don't know how, I mean, I know she's in the courtroom, but you don't know physically how Maya's doing today, true?
No.
Okay. But you can tell physically she's doing better today than she was when she was brought into All Children's, true?
Well, first, I didn't see her when she went to All Children's, and today all I've done is see her from a distance. That doesn't mean that she can't be in severe excruciating pain.
Has anybody, have you, in your time working on this case and working with Mr. Anderson, did you ever ask Mr. Anderson, how is Maya doing today?
No.
And when she saw you, she was in a wheelchair, right?
Yes.
And now she's walking today.
Yes.
One moment, please.
The coloration of their faces, they're not getting flustered. I have two feeds that I'm flipping back and forth between. Let's see.
Sure.
They're going to approach. They're going to talk about an exhibit. On redirect here, they need to go into all those areas where the doctor said on the cross, where he said it's not just a simple yes no. I can't just say yes no or true. There's a bigger picture. That's hopefully the plaintiff's lawyers were writing down every single time that came up, and then said during cross-examination, you said this. Would you like to expound on that? They need to open that up and let him answer all those questions and fully flesh that out to the jury. Hopefully they'll do that here. Stop flipping the feeds, says Beth. Maya looks healthier on this one than she does on this one. It's just the coloration looks better, so we're going to stick with this one. It's like court disco. Now, it's probably triggering somebody out there. I do apologize. The court recorder sitting there in a suit, I might add. I believe that's him in a suit doing the typing. It seems like the desk is too small for him, and he's constantly getting crowded. So look, see the lectern right there? This angle, we can see the backside of that lectern. There is a microphone flat on the table next to the podium mic. So the podium mic that comes up on the gooseneck arm, that's what the sound is going into the courtroom with. On the table next to it is a microphone that is sitting flat on the surface. It's like a floor mic. And it's great for conference rooms or on conference tables and things like that, as long as nobody's shuffling papers. But it's picking up all the sounds of the papers, and it's not being carried. It's not being picked up into the courtroom, so the court reporter's not hearing it. It's just people in the feed that are hearing it, and that's why we're getting that shuffling. And it's hopefully they can change the mic to one similar to what the judge has. If next time we get a close up of the judge on his mic, or even the I think the witness has one as well. The witness stand. There's an extra little wireless mic, or extra mic that goes up and clamps on the edge. I was going to see if I could show you one. I don't have one right here, but there's a secondary mic in addition to the one that's on the gooseneck, little flexible arm that's picking up the sound. If we could switch to that on that table, it would be night and day. This trial would be, none of us would have headaches at the end of the day. We're looking right there. That picture was Jack on the left, Kyle on the right. That is Maya's father and her brother. There they're back, right there. Thank you, cameraman, hearing me and responding. So that's them. Everyone's drinking smart water. Here's Maya in front. I'm not sure how they chose this positioning, but lots of microphones all over in this courtroom. They're all over the place. This is in Florida. This is in Venice, the city of Venice. Smart water good. Dasani is a no-go. I personally, my personal favorite, I've got to go with Deer Park. One day, I hope they sponsor me, because I've bought about a truckload, 40,000 gallons of this, and eventually I hope to get a free water out of it. I do like the Deer Park water. This one, let's see. This particular batch appears to be bottled in South Carolina, Chesterfield, South Carolina. If you have any ins with Deer Park, let them know. I sing their praises all the time. I'd love to be sponsored by them. I reached out to them. They have not replied. I'm not sure why they would, but I just want some free water. Is that too much to ask? Okay. Save draft. I was in the middle of an email I forgot to write. I will get back to that. Let's see. Please set up Bitcoin donation address. So
set up BTC donation addy so each one is taxable winking face.
I have to pay taxes on my Bitcoin. How do you get around paying taxes on your cryptocurrencies? Every time I buy and sell, I end up paying taxes.
Here's the jury. My conference is going to take a few more minutes, so what I'm going to do is I'm going to send you for a short break. Let's try to keep it 5 minutes or so. Do not discuss this case amongst yourselves. Do not do any investigation and receive no information. Let's try to keep it to 5, maybe 10 minutes, okay?
All right, for the next thing.
I don't have the patience for a water filter. We have a couple, but they take forever. Sell for cash, then donate. So you just need a wallet?
Okay, the jury is out of our presence. Everyone please be seated. Mr. Shapiro, Mr. Anderson.
Oh, Patty.
Dr. Chopra need to step outside, or can he
sit here while you do what you need to do.
It's up to Dr. Chumper. If he wants a break, I have no objection.
Do you want a couple-minute break, sir?
Yeah.
Okay. Why don't you come back in 5 minutes? Just remember, you can't talk to anybody about your testimony.
Okay, doctor's going to step out.
Just so the clerk's aware, we're now talking about Exhibit 3035 and perhaps certain pages, including 0024. And we're going to wait on Mr. Shapiro to give us additional pages to look at. Do you want me to sit here, or do you want me to come back in 5 minutes?
You're welcome to come back in 5 minutes, sir.
Okay, I'll be back in 5
Oh,
minutes.
wow. We are really taking a break. We're taking a 5-minute break. Judge is out of the room, so we're going to wait. Okay, so I will tell you that the water in my town is delicious, but you sure can taste the water tower in it. I mean, it's there's nothing. It's not like we have to deal with some of the problems that other parts of the country have dealt with the water that looks bad, smells bad, and tastes bad. We just have the taste bad one. Let's see. Drinking only filter water, reducing plastic. That is a worthy endeavor. We try to recycle if that helps. Hey, look who's here. Hang on one second.
Mr.
Ivan, how are you doing, my friend?
Hey, everybody. I know it's just a quick break. I'll be short. I just wanted to say hello and howdy and how we doing?
We're doing well. It's good to have you back. A lot of people were asking, making sure you're okay. I told them you were.
I know.
So I said, don't worry about Ivan. He's like a bad penny. He always turns up. So.
Hey, my mother calls me, my mother calls me the almighty cat. I always land on my feet.
Yep.
And so, but I just wanted to voice my appreciation to not just the chat and all the comments, but you and Ricky for being my liaisons. And I didn't mean to put you in a weird spot there, but everything's good. Everything's okay. So how we feeling about the trial so far?
Well, today's been amazing. I would say up until today, defense was winning, and it was mostly on the objection grounds. They were winning on the objections, making sure keeping evidence out, preventing the plaintiffs from going into areas or bringing certain things before the jury. They were winning, I would say, even 8 to 9 out of 10 objections on that. Today, that flipped. And we had some powerful testimony that really was it's.
I thought the guy from Harvard was incredible, right?
Yes, the current attorney.
I don't know where Harvard is. I've never heard of it. But,
Dr. Pradeep Chopra. You didn't go to Harvard? You're not an Ivy School kid? No,
I don't know.
I never would have guessed.
They turned me down.
Sure you did. I'm not either. So, no, it's been good.
Yeah, he was great. And boy, we would all be so lucky to have a doctor that cared that much, right? I mean, he seems so invested.
I've had some really good doctors whose bedside manner was awful. And you feel like, can I say something here, or is it, are you just going to do your thing and I'll be better at the end of this? But, I feel like an intruder in my own hospital room or my own patient room. But at the same time,
he seems to have better bedside manners than the veterinarian that pulled a gunshot wound out of my leg. He just seems to have a little bit.
There's Ivan talking about days gone by, going to the vet at midnight to get a gunshot wound treated. So.
But no, he really seems invested, and you got to take your hat off to him because he has nothing to gain by this. He's just doing his job, right? I mean, he's just saying what he knows.
Yeah, and yes, he's earning a lot of money. Okay, as far as expert witnesses go, he's probably going to be on the top end. I'd be surprised if his bill is less than $20,000 for everything that's going on here. He had to review 7,000 pages of documents. Okay, over how many weekends? 4 weekends, he said.
I like how he said a boatload. We're going to need a bigger boat, sir.
Did he say boat? I heard butt, but okay.
Did he say yeah.
It was the accent. I couldn't tell. A buttload. Either way, it was a lot.
Lost in translation, right? Yeah.
Right. So, it's either a butt ton or a boatload, one of the two.
But he was right on the money, and like you said, I think the plaintiff really I hate saying the word scored points, but I really think they did. And, they came prepared. Like, we knew they would with that kind of, dollar amount attached to it. But, usually when you have experts or doctors, like, they're from, 4 different directional schools, Southeastern, West Central, Miami University or something. But this guy's from the top of the notch. And so they brought their A game. And so it's going to be, how do you break that down? I mean, I guess I'm just patiently waiting to see, because the defense is going to have their guns too.
Yeah,
Johns
they'll have their
Hopkins,
moment. When we look at this trial, at the end of the trial, the plaintiff is going to have used X amount of hours, and the defense will have basically the same amount of hours available. And if you look at the scale right now, it's been all plaintiff. We've got 10-1 plaintiff hours to defense hours. So we're definitely going to see the other side of the coin or hear the other arguments. You're going to hear experts come in that are going to say the opposite in a lot of cases, especially about the treatment of care that was received at Johns Hopkins Hospital. They're going to say, yes, they did everything right.
Well, and just to put it out there, I know some people have asked in the chat, like, just to answer a question on the air here. So in a civil case, what does the jury have? It's not unanimous like it is for criminal. So what does a civil case have to do?
It's like 50 plus 1, right? 50% plus 1. A simple majority is all they need. But that's my understanding anyway. So, but nobody's going to jail at the end of this. Everybody, when this court case is over, everybody's going to walk out. Judge
Speak
goes
for yourself, sir.
Maybe someone's going to confess to a crime and end up in the slammer. But really, it's just money. It's about money. It's about reputation. It's about if you're for the family, it's about holding someone accountable they think should be held accountable and making sure it doesn't happen to some other families. That's why they're asking for the amount they are.
And honestly, I really don't feel like it's about the money for these people. Like, I think that dollar amount, like, don't quote me here, but like, when we were considering for my daughter suing Marshfield Clinic, the lawyers that we talked to, the lawyer sets the amount, at least in our case. I don't know if that's across the board, but when you're talking about suing in a civil case, especially for a claim this large, the lawyer is the one who sets the. It isn't like Maya was up late one night and said, you know what, $200 million. Like, that didn't happen. Okay, so like anybody who's thinking they're money grubbing or this or that, like, that isn't how this works. Okay, so. It's all about fees. You know what I mean? And so I've seen a couple people say, like, how do they think 200 million is the right amount? It isn't about the amount. Like, it's about making them feel it. Okay? Like, and that's it's about making them feel it.
There will be a point in this trial where they're going to break down that dollar amount, and they're going to say, probably towards the end, they're going to say, look, this is how we got to this number. Maya's care. This will be something she goes through for the rest of her life, and according to the testimony we just heard, that the hospital's responsible for that, or contributed or caused it.
There's no amount for life.
Yeah,
human life.
Whoa! Somebody just tripped on the camera, I think. How do you say how much to say there?
I'm just looking. They just handed me
exactly. You can't quantify human life, and that's the whole reason we didn't sue in the first place.
And review. Let me know if there's any.
We didn't want their money, and we knew they'd never admit wrong. All right, get back to it.
All right, thank you so much. Thanks for the call. Good to hear you again. Love you, man. See you. Bye. Okay, so they're back here. I think there's going to be a moment when they break down the money and say, this is how we came up with the number. The X number of million because of the treatment, X number of million because of the loss of family member, X number of million because of the failure, and this much in damages as that goes towards making sure the hospital has incentive to not ever let this happen again to another family. It'll all add up, and somebody rolled the dice.
Thumbs up button, or I'll drop Yvonne off at her house.
Oh man, Cachette. It's getting forceful with the hit the like button. So thank you, Cachette. Appreciate that. I like this guy's tie for a reason. Which tie are you looking at? This is interesting. They're all huddling around one table. What are we looking at? A single document. Defense handed it to the plaintiff. We're not allowed to hear the discussions between counsel like this, so they have turned off the mics for this. It seems troublesome for the plaintiff. Let's see if they do a sidebar here. They're going to approach.
Right. I mean, we don't need a sidebar at this point. What are the? Is there an agreement, or are there objections?
There are objections, not to the complete document, but there's objections to the introduction of explanations of court hearings, court strategy, and the DCF.
Well, time out. Just tell me specifically what pages we're talking about. In Exhibit 3035.
3035-12 would be one of the ones that if we're going to go into this with this witness, I would want recross on.
12, and then what are the others?
17, I think, right now.
3035-22 and 3035-23.
Okay, so can someone put up 12, 3035-12?
I don't think this would open up other cases. If somebody else has a case that's similar, it might be more likely for a settlement.
I think these are together.
If the fact patterns are similar.
If you look down under 3 p.m., Kathy stated parents are still in court reviewing patient's case with judge, and they do not anticipate meeting will conclude before 5 p.m. And my concern with this, Your Honor, is that I don't know what this witness is going to say once they open the door to the DCF matter, because I have not briefed him or prepped him, so he knows the rules. And so when we get into the DCF stuff, I think it's going to be the Wild Wild West. And this is loaded with it, including, if you see the next page, Judge would like appointment rescheduled sometime tomorrow morning. We're going to be starting to try the DCF case too. So if you look at the next page, it's more clear.
Page 22?
Yes.
This is getting spicy stuff. Division of Child and Family Services. Basically
CPS has been contacted and is going to come to All Children's this afternoon to begin their investigation. I thought that what's the date of that? I thought that was out of evidence in terms of being used for cross-examination, but.
Well, here's where I'm at right now, Mr. Anderson. Again, this is all predicated on what you're going to do with this witness. If I already told you, if you wanted to go into 3035-0024 with this witness, I'm going to let you do it. But so far, these other documents will probably come in so far. I mean, and yeah, there's some things in here that I'd rather not be, but the Nemours issue probably is going to have to get explained somehow to the jury anyway.
Well, it's fairly complex, and again, what happens if the witness who doesn't hear anything, doesn't know anything, starts telling what he knows about the
witness can get into something that's been ruled
fair it was,
inadmissible.
all of the different things that we're alleging. I don't know what his knowledge is on that, Judge. And so it's very likely, I think, that we're going to get a lot more. This particular point here that they're trying to raise, I think, can be covered in other ways. But the main thrust of this is that they're getting DCF involved. It's the 9th. It's 2 days after they came in.
Well, again, this is predicated on what you're going to do. And, I'm not going to tell you how to try your case. It sounds like you don't need this witness to talk about the issue that you want to talk about, but hey,
he's got an issue.
You feel like you want this witness
to bring up
to make those comments.
Witness could bring in.
Then I'm going to let you address the 0024 document, but on cross-examination, then I'm going to let them address at least 12 and 22. I haven't looked at 23 yet. So if you don't go there, then we don't need to make any rulings. If you do, then we will. So it's up to you.
My biggest concern is I was hoping to have a couple extra hours this afternoon, which are rapidly evaporating.
That's his biggest concern? He wanted a day off? Man, I've got a spam call. Oh, man. Hello? Hello?
If they're just going to use those two, fine.
Well, there's
Hello?
a third one. I didn't look at 20.
You're live in court. Okay, never mind.
Potentially 3035-23.
They hung up.
Okay, I guess not that one then.
Not 23?
We'll take that one.
Yeah.
I beg your pardon. We'll take 23.
Yeah, 303523 would be.
Yeah, we'll
Okay,
take 23.
Put 23 back
Get
up,
those
please.
printed out somehow.
Yeah, we'll take 23 as well.
So if the plaintiffs approach this topic, whatever it is, with this witness, because they've got a good witness the jury believes, if they want him to testify to something,
Okay, so
the judge is going to
let
let
me be clear.
defense bring in this document that the plaintiffs
because
don't
I'm
want.
going to allow 3035-24. We're also going to allow in 12, 22, and 23. Is that correct?
That appears to be it.
Mr. Shapiro, do you agree?
So they're taking a gamble here, especially because the judge has said it looks like the evidence you want to bring in could be brought in under a different witness. But maybe this witness is more believable. They think this witness has more of a rapport with the jury, and that would
Just get a proffer from the plaintiff of exactly what he plans to ask the doctor, only because the doctor said he doesn't know anything about the Moors. And so I'm trying to get a sense of how deep this is about to go and how we're responsible.
Well,
Because obviously we don't want to open up.
Let's bring in the doctor, put him on the stand, and see what happens.
Okay.
Outside the presence of the jury.
The judge is like, oh, let's do a dry run. Okay, so we've seen this before. We saw this in the Murdaugh trial with when they brought in a witness, and we had extensive testimony outside the presence of the jury. This is to see what would happen. We're literally trying it out. It's a dry run in the questioning. After this is done, they'll make a decision based on how it went. They'll bring the jury in, and then they'll do it again. And sometimes when they do it again, sometimes it's identical to what happened.
We're going to ask you some questions outside the presence of the jury, and then we may or may not ask them again in front of the jury.
Right.
Mr. Anderson.
May it please the court. Doctor, in your files, do you have the Nemours Hospital records? Do you know?
I don't think I have them. I'm not 100% sure.
Okay. If I showed you a particular Nemours document, then in evidence,
it's not in evidence.
Do you think you can identify this as a Nemours transfer notice? Let me show. May I show it to him?
Let's just put it on the screen.
Let's put it on.
My impression was that Nemours refused admission.
Exactly, but we're talking now about the reasons why.
And when you say put this document, you mean 3035-0024?
Yes, sir.
Can I have one of the IT folks put it up, please?
If you could read that, Doctor.
So this is just to save time, this is a evaluation report on Maya?
This was a Nemours order for the transfer of Maya Kowalski and the reasons that it was rejected ultimately. And I wanted to ask you a question. I know I'm in the interest of time. Assume Jack and Beata Kowalski had researched and determined that Nemours does not have a comprehensive CRPS program.
I object to this.
We don't have a jury. Let's get the information out first. Then you can talk to us about your objections. Now, again, Mr. Anderson, let's not make predicate statements. Let's just ask the questions.
Playing pretty loose there.
Assume Jack and Beata Kowalski had researched and determined that Nemours did not have a comprehensive CRPS inpatient program. And assume further that the research revealed that it would be more of the PT that she had been through about 4 times. Assume further that from this form, as you can read, that the transfer to Nemours was based in part on Munchausen's by proxy assigned by Dr. Dees, who is not a psychiatrist or psychologist, let the record reflect. It says right there, pediatric
Comes another
hospitalist.
objection.
And so, do you have an opinion, assuming those facts, as to whether the actions of Jack
and Beata Kowalski in rejecting the Johns Hopkins reasons and methods of transferring Maya to Nemours in Orlando?
I object to my question.
We're improper.
I'm allowed to object before this. My objection is multiple. It's the court asked the plaintiff not to give a predicate, and then he just gave 6 predicates. But in addition to that, he's asking now the plaintiff to speculate on the state of mind of the parents. He's not disclosed as an expert on either and judge the reasonableness of their conduct.
Okay. Well, one thing I heard is you're now asking him an opinion. It sounds like this opinion wasn't disclosed. Is that correct?
He had no opinion about transfer.
Something just got printed off.
Well, they were going to, I'm sure, open that door. I felt like they did on their cross. That's why I stood up.
Well, they opened up the door about Nemours. That doesn't mean this witness can give opinions that hadn't been previously addressed.
I think that's a ringtone.
Or disclosed.
It's going to be a ringtone.
I would. I can't remember the specific 2 or 3 questions, but my memory is that the questions were designed to give the jury the impression that somehow the Kowalskis had misbehaved or done something wrong in rejecting the Nemours transfer. That was clearly the thrust of them. To me, that opens the door for me to point out that they turned it down because it was based on, in part, Munchausen's by proxy, and I believe one of these codes here is from conversion disorder for Maya.
Why isn't this testimony from Mr. Kowalski?
It can be. It can be, but I think...
To me, I didn't realize you were going to ask him an opinion that had not been disclosed. So on that basis, no, this witness can't testify to an undisclosed opinion.
Well, can he testify to anything having to do with his experience and the narrative provided affecting the treatment of the child and the family?
I don't understand your question.
Can I show him this? And he's obviously aware of the prior questioning, and ask him whether his experience would be that this transfer notice being signed by the Kowalskis, is it...
Time
out.
Sir, do you know anything about the possible transfer to Nemours?
All I know is that Nemours refused transfer.
Okay. How did you come to that information?
It's somewhere in the records. That's the only way I would have known it.
Do you know any of the details as to why the transfer was refused?
There was no details, but can I just put in something?
Sure.
If I were, as a physician, and with 30 years of experience, if I saw the word Munchausen by proxy, I don't want that patient.
Okay.
Irrelevant.
Anything else?
That would probably be a pretty good question, if allowed. Having seen the Nemours transfer notice, would you, as a physician, want to accept the patient? Answer, I gather, is no. And then I would ask him why.
Just got a freebie delivered by the judge.
I'm going to object to that as an undisclosed opinion. My questions to him about transfer were very specific to malpractice claims, meaning there was an allegation from Dr. Chopra that my client committed malpractice and not giving her the proper therapy. The only reason I was asking about transfer is part of the defense of that is all Children's tried to make a transfer of the patient to a center in Nemours that specializes in comprehensive regional pain syndrome and in the rehabilitation of that, and that was not consented to. It had nothing to do with his state of mind about whether a mom should want it. It was purely as a defense of the malpractice claim, that very narrow issue.
Well, here's where I'm at. The issue of Nemours, I think the defense has opened that door. And you're going to be able to call whatever witness or witnesses to explain. It doesn't sound like other than seeing some sort of reference in the records, he really has details as to what happened or didn't happen with respect to the proposed transfer. And so I don't think this is the witness for you to go into that.
I have a possible solution then. I'm happy to not go into this with this witness. If the court enters an instruction that strikes the 3 questions about the transfer to Nemours because they were asked before it was put into evidence.
Yeah, but there was testimony about it 2 days ago as well. So it's...
I probably objected at that time too.
I don't recall. I really don't recall.
Well, our problem is this, Judge. If we're going into this, the jury should not be left hanging with this impression that Beata and Jack were being unreasonable. We have a right to rehabilitate, or whatever you want to call it, by pointing out that if they sign this, they're signing on to agreeing to Munchausen by proxy, among other things. And it's just not fair to our side that if the jury hears one side of that story, they won't hear the other side.
And again, I've said that you can call witnesses because the door has been opened. The reality is, I'm not going to allow in an undisclosed opinion. I think that's pretty clear. And it sounds like you're now trying to get him to make assumptions or assume a hypothetical to give an opinion that he has not previously given prior to today. And it's no issue with Dr. Chopra because I don't think this was something that was ever asked of him. So, you know.
I can explain this.
I told you earlier, if you're going to want to show this record, that's fine, but you can't ask him opinions that were undisclosed. And once you show that document, we're showing the other documents that we were talking about. So,
well, you know, it really puts me in a dilemma here, and it's not a dilemma of my making. And the defense was allowed to ask questions of for a witness for documents that were not in evidence, thus leaving the jury with a certain impression. So
I think he's right here.
I just need you to decide.
We have 1 moment, Your Honor.
Well,
literally 30 seconds.
Okay, this is some heavy duty legally lawyering here. The defense has some questions about. Were you aware that Beata and Jack refused to transfer?
Dr. Chopra, I'm showing you Exhibit 3035-0024. Do you have it in front of you?
Yes.
And does there appear to be a series of diagnoses in the middle of the page by a Dr. Dees, a pediatric hospitalist?
Yes.
And is one of the diagnoses assigned by Dr. Dees Munchausen by proxy?
Yes.
If you turn the page, is there...
I can turn it. Somebody else will.
Turn the page.
All right. But
it's on the computer.
There's a second page for a place to sign, which we'll bring up. And that's all I'll ask you. Was there a place where the Kowalskis were supposed to sign to agree to this for transfer? That's my own. Those are 3 factual questions.
There's no place for the patient or the patient's representative to sign.
Well, it says E-level, encounter E-level signatures, order-level documents, and so forth. It's kind of in bureaucratese, but this is, I believe, what they were presented with.
he gave his answer.
Wow.
All right, so I don't ask him about the signature page.
I don't know what encounter level e-signature means.
E-signature is one that's sent through the court. Yes.
He doesn't know.
He doesn't know.
Okay.
So
I
I'm
can
not going
ask
to tell him for him to turn around and say it. So.
Well, I understand, Judge. I'd like to ask the factual questions here because I don't want the jury left with that impression. And it could be 4 or 5 days before we call Jack Kowalski.
If I understand, Mr. Anderson wants to address with Dr. Chopra the reasonableness of accepting transfer with a diagnosis of Munchausen in the record is an undisclosed opinion.
I think at this point it's just the last 3 or 4 questions, the factual questions he asked about the document.
Which they brought in.
And the problem with that is the redirect, if the implication, I don't think this is a secret, if the implication is going to be that we would have accepted a transfer, except now that there's a diagnosis in the record, it's going to open up a redirect on the fact that it was also in the record in 40 other medical records and providers, from Lurie's to et cetera. I don't know how much of this I need to get in front of this witness. It's just...
That's a difference between a diagnosis and a theory.
Here's where I'm at. Those questions that you just asked Mr. Anderson, except for the
last one,
parent signature question, I'm fine, and I'm fine with the 0024 and 25. But if you go there, I'm going to allow 12, 22, and 23 as well. So I just need you to decide right here, right now, whether you're going to use this witness to do it, have this discussion, or you're going to call someone else down the road. And I know you feel like you're in a box, but at this point in time, you got to make a decision.
Well, over my objection, I probably at this point will hold off, but with the document. But I will ask questions about does he know the basis for the transfer? Does he know the basis for the transfer in part was Munchausen by proxy?
Okay.
Is that okay?
If you're basically now going to ask him questions,
he's going to allow it anyway
off of this document. I see that as the same thing as us introducing and showing the jury the document. So
that's pretty much the way I felt on their cross-examination.
Mr. Anderson, we are where we're at. Do you want to use this witness to talk about the Nemours issue as I just outlined, or are you not?
One moment.
Okay, so he's in a bind. Defense did some sneaky lawyering and were able to get to a point that put the plaintiff a little on their heels regarding the family's decision to refuse to transfer Maya to another treatment center. Defense is sort of won that little point, and the plaintiff could argue and say, "Let me clarify that by expounding."
I got a jury waiting.
But if they do that, the way they bring this document in, it's a gamble. This is a tough call.
Very difficult. One more question of him, and then
in proffer or
proffer
outside or with the jury.
Proffer.
Okay.
Are you able to identify this as a transfer form as opposed to something else?
This is a report of an admitting nurse from Nemours.
Okay. And can you see from this document why we have an admitting nurse at Nemours giving this report?
Yeah, I would object to this speculation.
You can answer the question.
Did that go up by one?
Sir, do you know the answer?
If you don't know,
what's the question?
Yeah, the question is, do you know why, at this juncture, a transfer nurse was involved?
Well, yes, that I know. All children wanted to transfer Maya to Nemours for rehabilitation.
And then what does the diagnosis in part show as a reason assigned by Dr. Dees to transfer her over?
It shows Munchausen by proxy.
And in your opinion, did this child have Munchausen by proxy? That is in the report and in the record.
Absolutely not.
Right. I'll use it.
He'll use it. Boom.
Anything before I bring in the jury?
I don't think so.
So to be clear,
so
at this
he's gambling.
Time, and I'm not making this, but are we admitting 3035, 12, 22, 23, 24, and 25? Is that correct?
Yes, Your Honor.
Believe so, Judge.
No, wait. I don't.
There's a portion of that.
Judge is like.
I beg your pardon, Judge. There's a portion of.
Judge has had enough.
24, I believe it does make reference to dependency court proceedings that I would like to redact before it gets admitted to evidence.
He wants. They're saying if plaintiff goes here and brings this document with these questions.
I'm not fond of this entire exercise, but be that as it may, I feel like Johns Hopkins, by its questioning, has put the issue of Nemours squarely into contention here, and the plaintiff has a right to discuss that.
I don't quibble with that a bit, Judge. That's not the point. That's not the point of what I'm saying.
If they'll withdraw the testimony, the attempted cross on something that was not in evidence, then I'm fine, and we can go home.
Just for the record, I didn't question the doctor on a single record from the Moors. It was about the records from all ones that were in evidence.
Yeah, the testimony the testimony stands at this point. So the question is
so
and again,
good.
it's the same question I asked you 10 or 15 minutes ago. Are you going to want to use this witness to talk about those factual questions that we just were talking about and your opinion on Munchausen by proxy that you just elicited?
Yes.
Or are you not?
Yes, he will.
How long do you plan to go today, Judge?
What can I do to get an answer out of you?
He needs to say yes. He needs to say yes. I want to use it.
I think. Use it.
We're going to use it.
So then my question is 12, 22, 23, 24, and 25, and I now am hearing from Mr. Hunter that he has an objection to 25, which we should have probably told me 30 or 45 minutes ago. So
It's basically the bottom of 24, Judge.
can someone put up 24, please?
So he's going to, now the defense says, if he does that, we'd like to bring in these documents. But now they're saying, but we object to part of the documents we'd like to bring in. So I'm going to turn my face off so we can see. Let's see.
Okay, what specifically are you talking about?
It makes reference to having an order in place.
Just tell me the specific language that you're talking about.
Patient.
Patient must
Just
have
go ahead and
court
say
order.
it, Judge. I'm sorry.
So a patient must have court order in place to be transferred?
Yeah.
Is that what you're talking about?
I was talking about the reference to the court order, and there was one in here earlier that there was reference being made to the family being in court in front of the judge and would not be available until the next morning. That was what I was really concerned about.
I mean, is it any surprise to the jury that there were dependency court proceedings going on?
No.
And we're not trying that case, but
Okay, as long as that's understood, go ahead, Judge. I'm sorry.
okay. So the court at this time, Madam Clerk, is going to receive 3035 pages 12, 22, 23, 24, and 25. And let's go ahead and bring in the jury.
Bring the jury. Okay, now we back up in time. Okay, we warp back. We're going to play the little sound effect because we're going to go back to the moment that the doctor came back in the courtroom. They started asking him questions, and he's going to be asked questions that we just heard. And this will be in front of the jury. And they're bringing in this document specifically talking about Munchausen by proxy and about how the family was basically agreeing to that if they agreed to the transfer. We're going to hear some objections because, first of all, I don't think that the plaintiff's attorney can ask the questions exactly the way he did during the proffer, and that he's going to stray beyond that or outside that realm where he said he was going to go. Now that he decided to go there, it's going to be fun.
Members of the jury, I want to confirm while you're away, you did not discuss this case amongst yourselves. You did no investigation and you received no information. Is that all correct? Correct. And I want to confirm that since the last time you were with us, you were not approached by anyone about this case. And that you have not seen any media coverage concerning this case. Okay. And I'll have to tell you, my wife always loves when I said it's 5 minutes. I seem to have a very elastic sense of time when it comes to 5 minutes. At least it wasn't one time I was with her and I said 5 minutes, and 4 hours later I was still at the office working. So I apologize, but sometimes things just take a little bit longer, and I'm glad I didn't have you sit here while we were having that discussion. So.
And you're still married.
And I'm still married, which is the biggest surprise of all. Mr. Anderson.
May it please the court. Insofar as the specifics of the day-to-day, month-to-month care of Maya Kowalski, would you defer to our physiatrist who has worked that out? Your opinion, would you defer to the physiatrist for the day-to-day minutia of the care?
I didn't, you'll have to rephrase it. I didn't get that question.
Don't worry about it. Okay. Don't
worry about it.
Cross, you were asked about an authoritative source, and I believe you answered that that it wasn't authoritative, and it might have been authoritative, but do you know if we can put up 1001 to 2718? Okay, I'm shifting gears because that's not the one I wanted, but I can use this one to get that point, which is my next one. You were shown on cross-examination this. Can we highlight that middle, the entire paragraph instead of just the top? Ooh. And can you read to yourself
little jab there,
the reason why Beata Kowalski said she's not allowed to eat?
According to a nurse from the day shift.
It's called, TPN stands for parenteral nutrition. I forget the first T, what the T stands for, but it's nutrition that's given through an IV.
And is TPN a ban on feeding until the diagnosis could be understood by the hospital?
No, there's nothing wrong on giving TPN. I mean, there are some risks involved when you give someone TPN.
Okay. And did it come to your attention, though, that there was an order from Johns Hopkins that prohibited Maya from eating until they actually diagnosed what was wrong with her stomach?
Objection, lack of foundation.
I wasn't aware of that rule, but that would be standard practice.
And so, if this is standard practice, and there was, in fact, such an order, would it be reasonable for Beata Kowalski to inform whatever the nurse was or whomever that Maya couldn't eat because there was an order saying not to eat?
Objection, it's lack of foundation. It's also speculation on the state of mind.
Well, it says that Beata said that she is not allowed to eat, that she was just quoting the hospital orders, which the nurse should have known.
Yep. Okay. There was also a question about a tethered cord. Let me show you Exhibit 1028-147.
I think I've got the objection number right. Let me know.
And I'll ask you there if we can highlight the line.
I keep making my face disappear so you guys can read the documents.
He says the patient and father state she saw her GP. What's a GP?
General practitioner.
General practitioner.
And so what's happening here? What does it show insofar as Jack Kowalski following up on the tethered cord recommendation you made?
He did. He did follow up.
Let me show you then 2004-44. It's the MRI and Dr. Wassenauer's records. Now, there are no findings there of tether cord, are there?
No.
Does it appear to you then that the Kowalskis followed up on your recommendation and found that now that they had the test results, there was no tethered cord?
There was no tethered cord. They did follow up on it. Yes.
You were asked on cross-examination about what was an authoritative source, and it was specifically the guidelines. I'm forgetting the phrase that they used.
Consensus guidelines.
The consensus guidelines. Do you recall that testimony?
Well, I was reminded about it. Yes.
Okay. And you said you were aware of it. Does it show that Stephen Cohen is one of the authors of that?
Yes, he's the first author on it.
And tell the jury who Dr. Stephen Cohen works for.
Johns Hopkins, all children's.
That's an objection moved to strike as inaccurate. I moved to strike it as an inaccurate statement.
It's just Johns Hopkins.
You can overrule.
Thank you. All right. So now turning to whether or not the Kowalskis actually transferred or the reasons. Let me show you what's been previously marked into evidence as 3035-0024. If we could bring that up.
I don't know if there was a settlement.
All right. And so in this, does it appear to be from Nemours?
Yes.
And does it appear to be a transfer nurse that is creating the progress note?
So, for the ladies and gentlemen of the jury, just want to explain. When a patient is transferred from one hospital to another, the second hospital sends over a nurse who does an assessment. And then based on the assessment, the second hospital will decide whether they want this patient or not. And that's this report.
So if you look at under Sandra Perez, MSW, does it say that she met with the Johns Hopkins people?
She met with, yes, she did. She did meet with them.
All right. Is one of the diagnoses already made and placed into this Munchausen by proxy?
Yes.
Doctor, what happens, and you previously discussed this, when a diagnosis like this is put into a patient's records?
I object to this.
He's already testified about narratives.
That question I'm sustaining.
If I...
Hold on a second, sir. I sustained it, so Mr. Anderson's going to have to ask you another question.
Okay.
What, if any, effect in your practice as a physician does having this Munchausen by proxy
There's an objection
in the record?
Same objection.
I'm sustaining.
You can't ask this question.
Yes.
All right. Well then, does it say that Johns Hopkins told them it was Munchausen by proxy
Objection.
among the...
Overruled the objection. You can ask that question.
Does it say Munchausen by proxy is one of the diagnoses?
Okay, I have an opinion on this.
Please.
Can I say? Okay. For one, they...
Objection, Your Honor. Same objection.
Well, the jury needs to know the truth.
Sir, what I need is you to answer the specific question.
They're going to ask to strike that.
Okay.
Which I have now forgot.
The question that you'd asked was, is Munchausen... No, what
happens when... Well, that one's already been overruled. I said, was Munchausen's by proxy assigned by a Dr. Dees with Johns Hopkins?
Yes.
And Did Maya have Munchausen, or did Beata have Munchausen by proxy?
No.
And is that a psychiatric diagnosis?
Yes.
Is it a negative psychiatric diagnosis?
Objection.
It's a grossly
Overruled, you can, the answer stands.
It's a grossly negative psychiatric diagnosis.
All right. And so if you look at the bottom, does there appear to be some editorial about Maya with Johns Hopkins?
What do you mean by editorial?
Okay. Was there a comment made about whether or not she could clearly move her arms to do so?
Yes.
All right. And so in the actual diagnosis for the transfer, which the Kowalskis would have to consent to, obviously, was there a finding that was, in effect, an admission that if they signed, it would be Munchausen by proxy, they would agree to it?
Objection, Your Honor, and scope and foundation relevance outside.
Scope, foundation, relevance.
Court, can I have that question again, please?
Court reporter is going to bring it back. I think it was asked pretty well. It may be allowed in. May be allowed in. Court reporter is going to re-ask it word for word.
Okay, and so in the actual diagnosis for the transfer, which the Kowalskis would have to consent to, obviously, was there a finding that was in effect an admission that if they assigned it would be Munchausen by proxy, you would agree to it?
I'm going to overrule the objection. You can answer that.
Boom.
Yes.
I can say.
If the Kowalskis signed it, they would be admitting that they have Munchausen by proxy.
Thank you.
Oh, that was the gamble, and it just paid off.
Is it defense turn?
Is it defense turn?
Well, one last question. Was this transfer notice for the purpose of CRPS treatment or for a psychological psychiatric treatment?
Objection.
Sustained.
Nothing further.
Man. He got it in. I was worried he was going to bungle it, and you guys were as well. The question was so unclear.
Yes.
Just because you were asked about Munchausen's and prior psychiatric diagnoses, are you aware of whether records prior to All Children's Hospital also contained those suspicions or diagnoses?
That's irrelevant.
I asked you if you were aware of whether other institutions prior to All Children's had also made those diagnoses or suspicions.
I'm just trying to think of the hospitals. No, I'm not aware of any.
So the totality of the records that you reviewed and everything you reviewed, you don't remember ever seeing either at Tampa General or Lurie's Hospital prior to All Children's their records containing their records containing either diagnoses or suspicions from other physicians about either Munchausen's or other psychiatric disorders. You don't remember ever seeing it?
Objection.
I know.
Across because facts are not in evidence. No.
I don't recall any of them diagnosing.
That's all. Thank you, Doctor.
Anything further from the claims?
No, Your Honor.
Let's have some jury questions.
You don't understand. The jury actually gets asked questions too.
Are you serious? It's a nice day.
Members of the jury, do any of you have questions for the doctor? I see at least 1, 2, 3.
Okay, we do have jury questions.
Lawyers, please come forward.
We're going to have jury questions, and then after the lawyers review the questions with the judge, look at the witness. He's like, I thought I was done. And this is rough. After these questions, if this triggers something with either the plaintiff or the defense, they also get another round of questioning. So this, just because we're at the jury questions, does not mean we're done.
Notes. I know you're trying to conserve paper, but we have enough paper for your notes. Just pull the whole sheet of paper, please. Thank you.
They're tearing the paper into small strips. Oh my goodness. So this cycle could repeat itself. We could have jury question followed by defense clarification or plaintiff clarification, and then defense cross clarification, then another round of jury questions based on the answers that came there. Generally, it doesn't go very long, very many rounds, usually 1 or 2 jury questions. But this is the clue into what the jury is thinking. This is such a key part of the plaintiff's case that this could be extremely insightful. Man, today's a fantastic day. We did not hear Maya testify today. We thought we were going to hear it because they said she would yesterday. But either way, it's been incredible. The doctor just wants, he doesn't care. He's making plenty of money, right? He's getting paid for his time. Just like he would be paid for his time had to be back at his practice and working. This is not going to pay for his houseboat or buy him that plane he wants. This is not like a huge cash cow. He probably makes equal amounts of money for his time in his practice. But this is tough. Amazing the gamble the defense took. You could see the dilemma the plaintiff took. You could see the dilemma where they're basically saying we're letting something in that could hurt us, that we didn't want, that we fought against if we, but they got put in a bind by defense asking questions and getting, over objection, getting some questions in that made them look bad. And now to make them look better, they'd have to introduce something that also has something else they didn't like. And it was a back and forth. And in the proffer, the way the answers came out, they said, this is worth it. We're going to take that chance. And here we go. That Alienware looks like a nice laptop. It is. It's a fantastic laptop. For those that don't know, the Alienware is the laptop on Maya's left shoulder. By the gentleman with the suit has that. That's a very expensive, and it's typically a laptop used for gaming, for high-end gaming. So if you were going to play like Call of Duty or something like this.
How many Holiday Inns he stayed at?
Ivan, witness is great, but how many Holiday Inns has he stayed at? Not enough for this type of exchange. Lawyers are still lawyering over the questions. Defense doesn't want them, you can tell.
Hey, Dr. Chopra, I have quite a few questions from the jury.
Here we go. Small stack.
Do you have an opinion on how Maya's CRPS started?
That's actually a very good question, and the answer is no, I don't know. What had happened was she was admitted, and that was before this case. She was admitted to the same hospital. She had been given very high doses of steroid for her asthma. And at that point, she developed pain in both her legs. And that was eventually diagnosed as CRPS. But we never could find out why. And that does happen in CRPS.
Okay, so that was good.
So the attorneys are aware, based on how he answered that question. I'm not going to ask the next follow-up on that.
Yes, sir. Mm-hmm.
The next question, is ketamine addictive physically or psychologically?
No, not at all. Not at all addictive.
Does ketamine cause constipation or continued use cause obstination?
No, not at all.
Okay. How do you simultaneously acknowledge this case is rare and unknown, but also answer that the treatment would have a certain outcome? What's the basis for your belief? Is it opinion or science?
Wow.
I didn't understand.
Very skeptical question.
How do you simultaneously acknowledge this case is rare and unknown, but also answer
that the treatment would have a certain outcome?
You mean case or the condition?
I think the question is case, but the attorneys and then the jury can follow up if I'm misunderstanding the question.
Well, I'll address both. CRPS is officially considered to be a rare condition, officially. But in reality, the incidence is actually very high. I have it here. It's about 200,000 cases per year, and the incidence is about 7% in children per year. It's officially considered rare because no one has gotten around to, because it gets missed all the time, so people haven't been able to accurately get figures as how many people actually have CRPS and was missed. This case of where a child developed CRPS and was accused of, parents were accused of child abuse, and then ending in a mother's suicide, is actually very common. It is worrisome, and it is extremely common, more than you would think.
The tie on the witness looks like it's a Harvard tie.
The follow-up to that, what's the basis for your belief? Is it opinion or science?
Belief of what?
Your answer just immediately before.
Oh, no, these are all facts. It's not my belief. It's not a rare condition, but that's my belief. It's not a rare condition. And it's a general consensus also. It's just that we haven't gotten the data going. No one has bothered to collect the data. So it's still considered a rare condition. And a lot of people want it to remain as a rare, patients want it to remain as a rare condition because the FDA then approves drugs easily for rare conditions. So a lot of people want that. And it's not, so it's my belief is it's not a rare condition, but the official statement is that. Any other beliefs?
Well, the next question
is,
and this is going back to ketamine, are there withdrawal side effects after long-term ketamine treatments?
No, not at all. No, you can be on ketamine continuously, and it happens. You can be on ketamine. Hospitals will put a patient on ketamine infusion continuously for 10 days, and then abruptly stop it, go home, and nothing, no withdrawal at all. That's the beauty of this drug.
And the last question at this time from the jury. Is it more common for the onset of CRPS symptoms to gradually progress or to just appear one day with excruciating pain?
No. This condition, if you don't treat it, it just keeps progressing, and eventually just keeps progressing till the patient eventually becomes bedridden, and then it's the end of it. It doesn't get better on its own, ever.
Plaintiffs, are there any follow-up questions?
No, they just want to stand up and clap.
Doctor, part of your review, were you able to determine whether in those instances where Maya went off ketamine, such as after Dr. Kirkpatrick, and before she went to Mexico, whether she ever experienced any withdrawal symptoms?
No, you don't get withdrawal from ketamine. I mean, she came back from Mexico and she didn't have withdrawal. No, you don't get withdrawal from ketamine.
And can you tell the jury, just so that when they're back there looking, what if it were to be withdrawal, if it was an opioid-like withdrawal, which I think is what they're thinking, what would you expect to see in her records?
Well, she would have tremor, like any other withdrawal. She would have tremors and, what's it called? Feeling like bugs under your skin, and all of those symptoms. Severe nausea, severe nausea.
All right, and it's sort of similar to alcohol or nicotine or substance, any addictive substance?
Kind of.
But ketamine. Is ketamine addictive?
Not at all.
Your witness. Oh, one more.
This
Can
is how many times
ketamine,
I've
have you seen in your career
makes this mistake a lot.
asthma attacks cause CRPS?
No, there's no direct correlation in that. There may be an indirect correlation, but not a direct correlation.
Thank you, Doctor.
I'm only going to owe you $1.
Is there a
one question? $1.
Is there a stop period? Do you have a button to push for stop?
I told you I'd pay you your $1. Yeah, it's going to be quick, I promise. Just to follow up on one of the jurors' excellent questions. The side effects of ketamine, those include nausea, vomiting, colorful dreams, hallucinations, and headaches, correct?
Yes, but I need to elaborate on that. If you give someone a whole lot of ketamine suddenly, let's say I gave you 200 milligrams of ketamine as one shot, you would have all of those. You would be seeing pink elephants flying around this room. But if you give 200 milligrams over 4 hours, you'd be fine.
Okay. So high doses of ketamine would cause those side effects, correct?
Again, high doses of ketamine given slowly over time, you probably will not see that effect.
Those are the potential side effects of ketamine.
Those are the potential, yeah.
Okay. I owe you $3.
Oh, yeah, I know. And $4 there, $7 today. My day is done.
No other questions?
Well, members of the jury, do any of you have any further questions?
He's like, please don't ask
May
me.
this
any.
witness be excused at this time?
Subject to recall.
I may hold him for potential recall later, but he may be dismissed today.
Okay. So, sir, what that means is you're free to go today. It's possible they might ask you back. So let's not talk about our testimony with anybody except for the lawyers, okay?
Okay. He hates me.
Thank you for being here, and have a good afternoon.
Thank you very much.
Okay.
Oh my goodness, the jury must love this
Am I
guy.
supposed to be first before everyone?
You can go right now.
Oh, cool.
And you might want to leave before we change our mind.
I know, one of these days.
Okay, he's very endearing. The jury loves him. He comes across as very sincere, honest, fun.
Okay.
And that helped the plaintiff so
Members
much.
of the jury, let's take care of a few housekeeping items. That's going to be our last witness today. So I know it's only 4 o'clock, and I'm sure you're really upset that we're leaving at 4 as opposed to 5. I know that there was a request earlier to kind of know what the schedule is, and I will tell you I have been discussing that with the lawyers, and I should be able to tell you tomorrow what our schedule is next week. And it's my intent, hopefully by the Friday of each week, to kind of give you a preview about what the following week's going to be, and if we're going to have some time. When I say time off, it's really time off for the jury because there are other things that we are doing outside your presence. So when I say time off, don't assume that we're not working. I will tell you the logistics that go into a trial are extremely difficult. And before I was a judge, I was where these lawyers are. And you're balancing witnesses. They've got their own commitments and work, and that's before you even get to the life issues like, a plane, gets diverted or a delay, or someone gets sick, or someone has to go to the hospital. I mean, there's just all the life issues that go on. So we kind of build into our schedule a little bit of time to account for that. The good thing for you right this second is we are a little bit ahead of our schedule. So I'm constantly discussing with the lawyers. Usually it's outside your presence, where we are, what witnesses we have going on. And the lawyers on both sides are working very hard to coordinate what witnesses are going to be here. So everybody knows when you walk through the door that we are asking witnesses questions and everyone is prepared. And so, the lawyers have done a very good job on both sides to do that. So I know that there is a desire for a schedule, and I will accommodate as best we can. Understand also that there are issues that sometimes crop up that, what will I know tomorrow might not be the same as what I know next Wednesday. And so I will do my best each Friday, if not before then, to kind of give you what the following week's preview is. Is that level of frequency sufficient for you all, or do I need to have a more rapid? Okay. I promise you that I will do that. And I do see, sure.
It would be nice if we knew that, October 15th, we would be needed here or whatever, so that we can make. I think the reference is for any known holidays or court holidays.
Well, I can tell you right this second that next Friday in the afternoon, we're not going to be here. Whether we're here the whole day, the morning or not, I don't yet know. I hear your point. There might be a day or two that I can give you this far out, but it's not going to be, but maybe a day or two. I'll talk with the lawyers about that. But I just, I'll get back to you on that, but I don't think there's but maybe a day or two that I'm going to be able to tell you tomorrow, hey, on October blah, 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 we're not going to be here. So, but I will do my best. Anything else on that issue?
So those were jurors' voices we're hearing as they're
tomorrow
asking about their schedule.
We'll be here again, and tomorrow is Friday.
Yes, it is.
So do not discuss this case amongst yourselves. Do not do any investigation. Receive no information. And based on my new questions, also please make sure that you're not observing any sort of media reports about this case. With that, have a good afternoon, and we'll see you tomorrow at the rallying point at the same time.
Realize we've got some strong opinions in chat. Let's keep it kind in there, guys. Appreciate it. Wow. I think everyone on the defense team should be smiling right now, because this has really been a huge win for them today, both in just the rulings by the court as different objections have been brought up, as well as the testimony that's been admitted that's come in.
Probably is a good thing that Dr. Kirkpatrick wasn't here today.
The
do
plaintiffs.
We need a break before we talk about whatever we need, or
there's not really prosecution. It's you got a plaintiff and a defense.
Okay.
So defense is the hospital. The plaintiffs.
What's the next issue? Obviously, the jury's out of our presence.
The plaintiffs is Maya and her team. The plaintiffs should be happy. I misspoke on that one.
Judge, I'd like to reprise my concern that I raised or made briefly, brought the court's attention to briefly this morning regarding trial publicity.
That was the court TV interview.
Yesterday, there was telecast on court TV an interview from Mr. Anderson in which he made reference to a Nuremberg defense, to the merits of the defense, and then he made reference to his confidence that when the jury hears how the DCF proceeding was manipulated behind the scenes, that they would act in a certain way. What concerns me about that, there's a number of different concerns about that, not the least of which is the nature of the reference to a defense asserted by Nazis.
Is that Dr. Borat?
But there's also a very real publicity issue with respect to what the jury hasn't heard or what the court is going to let the jury hear about something behind the scenes which suggests to me that there is reference to matters which are not yet in evidence and may never be in evidence. And I have a concern about that from the standpoint of, again, of jurors being approached by outsiders and that subject being brought up to them and having, as a result, a juror who otherwise is trying to abide by this court's admonitions tainted in some way by trial publicity. Counsel has indicated his concern about publicity that has been or comments that have been made in the media by the defense team at one point or another. I would say to the court that one of those concerns regarding Facebook posts by a spouse has been stopped definitively and will remain so. Otherwise, you have not heard any comment from the defense team regarding what's going on in this trial, and as far as I'm concerned, you won't.
Hey, and just block the people you don't like. It's all right.
The court basically make clear that we should not be engaging in publicity during this trial, certainly not engaging in comment on what the evidence may show or not, and certainly not talking about or editorializing regarding the merits of the opposing party's case or lack thereof. So that's the concern we've got, Judge, and I'm sure that Mr. Anderson's got something to say about it, but I don't think that it's untoward for the court to admonish all concerned that
hey, Ivan,
the
let's
place
let
to
it
try
drop,
the
man.
case is in here.
Let's let it drop for a minute.
Not out there.
I hear you.
Well, let me ask you this. Is there, other than a concern, a generalized concern, is there any basis of belief that there is tainting to this jury?
You've seen the same thing I've seen, Judge. I have no information at this point that the jurors have strayed from your instructions or that they intend to. Okay. My concern is not so much what the jurors may voluntarily do. My concern is more what the jurors may be confronted with as a result of this, or what pressure may be exerted on them as a result of an outsider or a third party's belief that these defendants are acting as if they were Nazis at Nuremberg, or acting as if they were manipulating the court behind the scenes, or some other nefarious activity of that nature. It doesn't assist the court or anyone for outside influence in the ecosystem of society out there to be in a position or even potentially to influence jurors or to exert pressure on jurors, or even make jurors feel like that there's pressure being exerted on them. So that's my point.
I think he's asking for a gag order.
I can't stand here and tell Your Honor that I'm aware of anything actually having been done to take that jury so far. But what I can do and what I am doing is standing here and asking that we all take steps to make sure that it doesn't happen going forward.
Mr. Anderson?
He's going to say they did it first.
I want to assure the court that I am very much aware of Rule 4-326 on trial publicity. And I know that I am not to be revealing facts. Schedules, fine. General view about the trial, fine. I looked it up. You can't put facts out there that are possibly not going before the jury, and you can't elaborate on those facts because, again, that is an outside source for the the jury to somehow access. And I have not done that. The defendants, however,
Here it is.
have repeatedly in multiple different media. I've just got one from the Daily Mail, but it appeared in the Tampa and the Tampa Bay Times. Exclusive. Maya Kowalski's mom, Beata, was fraudulently writing prescriptions for her daughter and faces charges before she killed herself. Florida hospital who accused her of Munchausen by proxy claims. And that was from counsel here, attributed in any event to counsel.
we asked them to take that down and withdraw that allegation because the court may recall that we had a hearing on a motion in limine because that was strictly an error in coding where it went in the wrong column. And the court saw that. But before we had an order from the court, the defense completely withdrew it, which to me says more about it than anything else. So I do not intend to violate, nor would I violate in any way, an ethical rule. If I am asked how the trial's going, I'm going to say, fine, it's going well. The defense scored some points, plaintiff scored some points. And these are, if you look at it, and I take great offense at them implying that I call them Nazis. In fact, if you watch it, Judge, I specifically said, well, some people call it the Nuremberg defense. And that is a term of art among trial attorneys for blaming it on I was just following orders. Now, at the time I said that, I immediately said, I do not mean to imply in any way, just to make sure that it was taken in the context in which it was intended, which was solely to repeat a way of expressing the defense's defense that I've known for 30 years, 40 years. So I don't think we need to be admonished to follow the rules of professional responsibility. I think we're all professionals in this room, and we're going to do our best to get this case tried with a minimum amount of error.
Mr. Hunter.
I think I don't have anything else to add, Judge. I think what was said speaks for itself.
Here are my thoughts. My number one concern would be that the jury not be receiving any sort of outside influence. And even leading up to this case, I took steps to protect the identities of the jurors. As you know, every time the jury comes in, I ask them about whether there's been anything, any discussion, or if they received any information. And now at your request from this morning, I've made a little bit more specific question, and I think that's fine and appropriate. Both of you are licensed members of the Florida Bar, and you both know Rule of Professional Conduct 4-3.6. So I don't think I need to tell you that you have to follow the rules of professional conduct, because that is an ongoing obligation that the lawyers have. As far as the content, certainly I've seen no indication that any of the media attention that has occurred in this case has been observed or provided information to any of our jurors. So at this point, I don't have a basis to believe that the jury has been tainted in any way, shape, or form. One of the greatest things about our country is the First Amendment and the ability to talk and to speak, the freedom of the press. And if I were to enter some sort of gag order when I don't yet have a basis to believe that any of the jurors have been approached,
there's the gag order term,
somehow tainted, then I'm afraid that my actions would be beyond the First Amendment of the U.S. Constitution. I'm just frankly not going to go there. Now, if there are attempts at the jurors and there comes an issue, then we might need to revisit. What the lawyers say, you're responsible for the words you say, and whether someone walks themselves into a defamation lawsuit, that's between the two parties, or a bar complaint, that's between the parties. But that's not an issue for me. So I'm not going to take any action other than what I did this morning, which is to ask the more specific questions. And I trust both of you as members of the Florida Bar to comply with the rules regulating the Florida Bar.
We understand.
There are any questions or clarifications?
This is the judge's dad voice right
None
now.
by plaintiff.
Okay, what's the next issue?
Judge, they gave us the list of witnesses they intend to call tomorrow. One by Zoom. We object to one of the witnesses. I don't know if the court wants to hear that now.
Ooh.
Might as well, since we're here.
Might as well.
So they plan on calling Meg Boland. Miss Boland, as I understand it, was a woman that was communicating with Beata Kowalski, She didn't start communicating with her until May of 2016, so after the ketamine treatment had been decided on by the Kowalskis.
Let me make sure I understand. Are you objecting to her by Zoom or objecting to her as
Oh,
a
no,
witness?
not by Zoom. I'm objecting to her testifying.
Oh, okay.
I'm sorry. So her first interaction with Mrs. Kowalski is May of 2016, and she's part of this Ferocious Fighters for CRPS. She has a child at CRPS, and all the communication is through emails or Facebook or whatever, going back and forth. Everything she knows about what's going on with the Kowalskis is hearsay through Mrs. Kowalski. It's all hearsay, and the court has previously entered an order granting a motion in limine that on DIN 2580 that lay witnesses' proposed testimony about their personal experiences with CRPS is in no way relevant to the causes of action in this case. The court at present is not in a position to evaluate whether those witnesses' communications to the Kowalskis prior to the Kowalskis' determination of a ketamine therapy regimen for MK pre the hospitalization, would inform as to the Kowalski state of mind to pursue the ketamine regimen. So unless, maybe I'm missing it, Judge, and they can inform me otherwise, but Meg Boland's first interaction, again, was May of 2016, long after the ketamine treatment had been started. She has a son with CRPS. She has a blog, a Facebook page about it, and all of her communications and all her knowledge are hearsay with regard to the Kowalskis.
Highness.
She was also one of the last, if not the last person to speak with Beata. And those conversations, once the court hears them, we are confident that you will find a number of exceptions to the hearsay rule, not the least of which is of then existing mental, emotional, or physical condition.
When was her last conversation?
The day before Beata committed suicide.
On the 6th or the 5th?
When was it? The day of. The day of the suicide.
Was it like after or before the hearing with the dependency court?
I assume it's after, because it wasn't that in the morning.
I wasn't there.
Yeah, neither was I.
It was January 6th,
I don't know, Judge. I can't tell you if what the case was there. I do know that the statements that she will attribute to Beata Kowalski go to the state of mind, probably, although no one knew the plan, somewhat of the motive and the pain, not memory or belief. She's not going to testify about memory or belief. Any reference to her son is merely a background side reference, and I am not intending to elicit the type of testimony that counsel worries about, which I believe is other people with CRPS testifying at length about how terrible it is. I think the jury has heard how terrible it is enough. And so I'm not bringing any of that out. I am bringing out, through Ms. Boland, Beata Kowalski's state of mind and descent to the point where she took her life. And she was the person that was most talked to in our view. We can continue on the different exceptions to the hearsay rule.
Let me ask you this. So besides the conversation the day of, are you intending to elicit testimony of prior conversations?
A couple of them. And again, it's going to go to Beata's state of mind as to whether she was looking at other options, whether she had a plan regarding the continuance of the ketamine or getting Maya onto another type of regimen. It'll go to some pretty fundamental points that the defense has raised and continues to argue about whether or not this ketamine use was a Munchausen by proxy or an abuse. And the conversations where Beata relates, and they're not lengthy, but where Beata relates that, at least our parts aren't lengthy, but where Beata relates what she's doing and why she's doing it, clearly fall within the exception and are important for the jury to hear, to evaluate whether this mother was doing something crazy or whether she was of sound mind.
Judge, this is the type of genie that can't be put back in the box. I think there's going to have to be a proffer with respect to what the hearsay statement is and when it was made and under what circumstances.
Well, I don't think I can rule definitively at this point in time because I do need to hear
Genies are in a bottle.
the circumstances of the conversation. It would seem the farther away from the date of Beata Kowalski's death, the less likely it is it's going to meet an exception to the hearsay rule. Okay. With respect to, yes, I can see a question or two about that fact that this witness has a child with CRPS.
Pandora was in a box.
We're not going to go
Genies
into
are in a bottle.
that witness's trials and tribulations with CRPS. We're not going to get into any sort of advocacy on CRPS. It's just my child has CRPS. You know,
Yes, Your Honor.
she and I bonded, or whatever it is.
Yes, sir.
Okay.
You
But
have this right.
I agree with Ms. Crowell's. I probably do need a
Proffer.
Now, is she going to
I
appear
love the
by
proffers.
Zoom, or is she?
It's a Zoom one.
Appearing by Zoom.
Did we let my judicial assistant know so we can get an email address for her to send the panelist information?
You what?
Procedure.
Oh, we didn't know that that was part of the procedure, but we'll take care of it right now.
Again, I need panelists, and like if a person's going to testify by Zoom, I think I put this in the order. We need to know their specific email address because for security purposes, it's only going to be a single link to one person.
Right.
And it's not going to be to you, when I say you being the plaintiffs, for you to forward on. It's got to be directly to the person who will be coming in. So we definitely need that, the name and the email address. Now, what time were you anticipating this witness testifying?
She's later in the day. I think she would be probably around 2. She's going to be after lunch.
So perhaps either before we go to lunch or after we go to lunch, we might need to have that proffer.
Kelly's got it covered.
Is that what I'm hearing?
Selena,
Whatever they're going to call it,
thanks for
Judge.
being
I
here.
mean, I definitely think we need a proffer because, again,
Yeah,
it's going to be hard to
I
handle
agree,
that otherwise.
I agree with you, Ms. Crowells. We'll do a proffer with respect to her proposed testimony.
Will the proffer be allocated against our time, Your Honor?
Well, it's not in front of the jury.
All right.
And speaking of time.
Speaking of time, here we go.
So you know, today plaintiff's 3 hours, 10 minutes for a cumulative running total of 10 hours, 15 minutes. Defense 1 hour, 15 minutes for a cumulative total of 3 hours, 25 minutes.
So where were we again, plaintiffs?
You're at 54 hours and 55 minutes.
That guy would choke will put you up to that.
10 hours, 15 minutes total.
This is a civil
what's the
trial,
next
so those
issue?
numbers should be equal at the end.
Ms. Crowells?
Okay. Judge, recall, we started talking about this, but then we didn't have time this morning. During Dr. Duncan's testimony, Mr. Whitney stated
Lawyer's tired.
at the beginning of a question, which I have the transcript of now, which said, if the record shows that MK did complain to the doctors at the hospital of physical and sexual abuse on multiple occasions, and then we stopped it and we approached the bench, and the judge informed the jury to ignore the statement. But we're concerned that that's not sufficient, and we would like the court to instruct the jury that there is no claim for sexual abuse by the Kowalskis. And there's no evidence that she complained to the, I'm sorry?
This is probably the time. So it's a bit of a story. When we were looking to dismiss Ms. Beatty, I had a conversation with my client, Maya Kowalski. And in fact, it's 2 texts which, without waiving the attorney-client privilege, I can provide to the court as to the day, which is about whenever we dismissed, I think it was last week. And
this is huge, guys.
He
Listen.
informed me
that she had, before the 17th, because it's noted in Dr. Katzenstein's notes, she will testify that, well, let me continue the story. I said, Maya, we're going to dismiss Ms. Beatty. Now, are you telling me every single encounter you had there? I need to know every single encounter, no matter how big or small you think it is. And she told me one story about them dancing around her to try to get her to get out of bed and dance, and we know about this. Then she broke down, and then she told me that she had a doctor come in, and she figured it was a doctor because she described him as being tall, thin, glasses, I think she said round glasses, and dirty blonde hair. With a lab coat on, she could identify his belt and his pants. The doctor walked in, male, without chaperone or assistant. The doctor walked over to her and said, "May I take a peek?" The doctor pulled down Maya's pajamas. This was pretty late in the day. I know it was short shorts or pajamas, but it had a drawstring. Pulled them down, pulled her panties down, and then stared at her vagina for, Maya said, long enough for her to be not only startled, but start to cry. Whereupon he turned around, went to the door, turned around his shoulder and said, "Thanks." She never saw him again. Now, as an officer of the court, I will swear everywhere, had I known anything about this, I would have immediately brought it to the attention of both the court and to opposing counsel. I then waited. I've waited for the past 3 or 4 days, however long it's been, because I wanted to corroborate before I brought this before the court. So Maya was able to locate a witness where approximately 2 years, a little less than 2 years after it happened, she told a young man who was a friend of hers what happened, and he is willing to testify about it. Then I went to Dr. Katzenstein's notes, and there's a very cryptic reference in there. And it says first, this is why I didn't catch it, first it says she denies any sexual behavior, misconduct, whatever. Then it does say, she does say a doctor, what was the exact terminology?
I get the exhibit number on.
We're going to pull it up for you, Judge, so you can see it. Anyway, we'll show you the exact language, but it was words, I'm losing my place here. It was words to the effect of the child, or I'm not sure, we're going to see in a second, did say that a doctor pulled her pants down and she was, I forget on the thing, it's been a long day, on the actual note, whether she said she was scared or whatever. I have checked this out with every psychiatrist we've got, and we've got a lot of them, as the court has seen, in an abstract manner, not referencing anything about the testimony here, but simply about repression, suppression of these kind of events. And I have learned that for children, these events are typically suppressed, and they are not brought out for years, which is why we don't have a statute of limitations on this type of behavior. And so I didn't know exactly when to bring it to the court's attention, except until I had corroborating evidence and I had determined that there was a profound reason why Maya did not say what she said. She is now old enough where she can explain it without, well, she'll still break down, but it is obviously upsetting to her. It was completely inappropriate. I don't know who the doctor was. I do know that Beata does not lie. And she said it was a Johns Hopkins lab coat, which she's very familiar with the Johns Hopkins insignia on the side. which puts me in a quandary because we neither pled that nor informed the defense of it because we had absolutely no idea. And the note placed after the phrase child denies sexual abuse made me think that that episode was just a normal doctor visit and made me think that it was before she ever went to Johns Hopkins. I mean, it's there on the bottom, and for the record, she denied a history of sexual abuse. She stated that one time previously a doctor had looked at her private parts but did not touch her, and it made her feel uncomfortable. And we believe, and we would like to add, to ask Dr. Katzenstein about this. And
whose note is this?
This is Dr. Wasnauer's note.
No. This is a Johns Hopkins psychology note written by Dr. Katzenstein.
I beg your pardon, it says primary care physician, Dr. Wasnauer.
And it's from what time?
It was, this was on October 17th
of 16, so she would have been in there approximately a week at the time. And so I then looked up the law, and obviously, Judge, you have very broad discretion here.
Obviously, this is something new.
To put it politely.
I'm sorry?
To put it politely.
I would have brought it to everybody's attention sooner, but I'm not going to release any of that kind of stuff unless I know.
This is how I think we should handle it. This is not a ruling. This is a suggestion. Let me get the party's view. And perhaps this is memo time in the future and not to answer right now. Obviously, we've got a question of late disclosure and whether it's within the pleadings or not. So perhaps what I need to understand is what the plaintiffs are asking the court specifically to do or not to do.
Are they asking to add to the charges or what?
An opportunity to respond. I mean, and I think this is probably one of those that we probably need writing and we need case law and to be clear as to what it is that you are actually seeking, Mr. Anderson. So
yes, sir.
Perhaps, and I don't think you're putting Ms. Kowalski on next week.
No.
If you were to provide your position, maybe let's see, tomorrow is Friday, by like noon on Saturday, and then let the defense have until, when I say close of business, probably the end of Monday to respond, and then on Tuesday we can have a dedicated discussion to the issue. Just as a spitballing ideas here. What?
That sounds fine, Judge. I mean, our requests are pretty obvious, but I agree we should all think about it, especially the defense. I have been in their position before. It's an unpleasant position. I know they'll object, but I think both sides need time to review this.
Your Honor, if I may, it's totally outside the pleadings. Not only is it new, so the only motion they can file is, at this point in time, is a motion, if they wanted to do it in this lawsuit and not some other lawsuit down the road. If they want to do it in this lawsuit, they've got to file a motion to amend their pleadings to add that to the complaint. And we can start this trial another year from now. But they can't try that in this case.
Well, I think because of the subject matter and the weightiness of what Mr. Anderson is saying, I kind of want to have a more formal process. I want to know specifically what the request is, and then we'll be able to review the defense's response, and I feel that might give me an ability to be able to make a more informed decision as opposed to just sitting up here and making this. Now, before all of that
disclosure by Mr. Anderson occurred, my thought, Ms. Crowells, was going to be, let's kind of wait and see, because I felt that the instruction I gave yesterday was sufficient to inform the jury that that's not an issue. And so,
and now he
could I
do
be
that.
talked into an instruction later on when we're going through the entirety of the instructions? Yes, but if I were to do it, let's say if I just did it tomorrow, let's say, I think at that point I'm actually focusing and highlighting the issue, which I think would be worse. So I was comfortable yesterday with the proposed resolution that defense suggested and I agreed with. And so nothing having to do with Mr. Anderson's disclosure, I probably wouldn't have done it given a further instruction on it in mid-trial. So is the timing frame like noon on Saturday for the plaintiffs to file whatever they're going to file, and then sometime before midnight on Monday a response? Are those times enough?
Yes, sir.
Okay, so that's what it'll be. The Madam Clerk notes will say that there won't be any formal order, but the plaintiffs will have it until noon on Saturday and then midnight on Monday night for the defense. And when you are filing your responses, please use that email that we use right before the trial to send a courtesy copy so I can grab it, because the clerk won't be able to docket those things over the weekend or at midnight.
Right.
Okay.
We have one other issue briefly.
Yes, sir. Is this before Mr. Altenberg, who's been so pleasantly waiting for days?
He wants his jury instruction.
Can we get a reminder of that email address, if not now, tomorrow? I think we may have misplaced it.
I'm hopefully sure that your assistants can do it. I don't want to do it publicly.
Yeah. Defense is reeling right now.
One of the witnesses for tomorrow is Ms. Deborah Hansen. Ms. Hansen is a former social worker at Johns Hopkins Hospital. As far as I know, life is becoming full of surprises. As far as I know, her only involvement in this case was an early encounter with the Kowalskis, and the fact that she phoned in the first report to DCF. And I'm trying to divine what the purpose of her testimony may be and why it is that she's being called as a witness in the case. If that's the purpose of calling her, we're going to submit that that testimony is irrelevant given the court's ruling.
Well, the fact of it obviously has come in or will come in, and I am not calling her to extemporize on making the call. I believe she made the first or second call. I think she actually made the first call. But she was there working in the PICU during this period of time when Maya was brought in and is witness to certain events. She is not a managerial employee. She has been gone from Johns Hopkins for years. She is a counselor and teacher at a very, very good boarding school in New England now. And her testimony will circle around party admissions at the time of Maya's being brought in. And she was an eyewitness to several events that are exceedingly relevant and material to this trial.
Is she going to be live?
She's going to be live. She's here.
Judge, I brought up the issue of her report, and that's the only issue that concerns me. Obviously, if she sees other matters that are material and relevant, we can deal with that.
I don't think there's anything I can rule on at this point. So
that was the only reason I brought it up was because of the report.
Any other issue other than the Mr. Altenburn issue from either side?
No.
Okay, Mr. Altenburn. And have you spoken with Mr. Elliott?
I have spoken with Mr. Elliott, and
Here's our
I
jury
got an email
instruction.
from him about 3 o'clock that indicated he wasn't too clear there was a hearing today, so.
It's okay. I worked with Mr. Elliott last night, and I can cover what we've agreed
Okay,
to here
okay.
or not agreed to.
Well, have you seen my amalgamation of the parties' requests? So what are your thoughts?
And my only, one thing, you have just a sentence that you did a double.
Maya
on
wants
it.
it to be gone for that.
Before the last paragraph, the sentence, "These 3 false imprisonment claims are not claims," is actually the first sentence of the next paragraph, I think. It just has an "and" in it in the next sentence.
So I doubled the same sentence, huh?
Yeah.
So that sentence should read, "These 3 false imprisonment claims are not claims about Maya Kowalski's custody
Period.
and are not impacted by the dependency court's custody order."
I think that would be fine. And the last sentence, my only concern is that the way this case is being tried, I don't honestly know whether the shelter order or the custody order, I should be more specific, will have any effect on all of the other claims. It shouldn't have any claim on medical malpractice, and I don't think it has any claim on battery. I'm not quite so sure about intentional infliction of emotional distress. So I had worried about the language of that sentence, but I discussed that with Mr. Whitten, and I believe that if for some reason that becomes an issue down the road, I could ask for some clarification on that, but I doubt that this is going to be something that's going to catch the jury's ear in a fashion that will confuse them down the road.
So let me see if I can translate what I'm hearing. You want me to say these 3 false imprisonment claims are not claims about Maya Kowalski's custody and are not impacted by the dependency court's custody order, period, and then not read that next sentence.
I would prefer not that sentence, or at least, or maybe just to mention medical malpractice and battery if you were going to do that. But we had gone back and forth, and that was a sentence that I had taken out of my proposal and given you the one that basically said that it wasn't relevant to these other counts.
Okay, I guess let me make sure I understand, because I don't think I understand.
Okay.
You want me to, that clause, "and are not impacted by the dependency court's custody order," are you okay with that or not?
Yeah, the first sentence is totally fine. It's just the last sentence.
It's that last sentence.
And I actually would just prefer to leave it out, but if we're going to leave it in, I would prefer the plaintiff's claims for medical malpractice and battery are not affected by the order, and leave it at that, because I'm not sure about all the other claims.
And Mr. Whitney, what do you say about that last sentence?
We prefer to have that sentence in. The fact that you only see medical malpractice or battery there was done specifically for this concern of the defense, which is the custody orders may at some time become impactful on, let's say, the negligent infliction of emotional distress or intentional infliction of emotional distress. So this is the first time I'm hearing that sentence should be stricken. What we discussed earlier this afternoon was that he was agreeable to that language because it only mentions medical malpractice or battery, which neither side has devised any way in which those would be impacted by the custody orders at this point.
Well, how about a more affirmative statement? The plaintiff's claims for medical malpractice or battery are not affected by the dependency court's order.
I don't object to that.
And again, does it say "and others," or does it say just
He's taking out others.
I would really prefer to have others. I really don't want to send the jury a message in any way, shape, or form. And I particularly don't want the defense to capitalize on any ideas that it somehow affects the remaining causes of action. So, an abundance of caution, I'd like to leave it in.
Well, if it becomes necessary, why at the end of the court, why can't I say it, this custody order has no bearing on the following claims?
Oh, I believe that the court will. I believe that you will.
So for today, I tend to agree with Mr. Altenburn. I like a more direct sentence as opposed to, such as. So the plaintiff's claims for medical malpractice or battery are not affected by the dependency court's order.
Well, not our objection. We just do not want the jury led to believe that they might affect the other counts, but we understand the court's view.
I don't think it's that big of a deal. I don't think that nuance is something they're going to focus on, and even if they did, I think a instruction at the end specifically identifying the counts could alleviate any possible concern that you had. And
very good.
Two other concerns.
Okay.
Hey guys, we'll
If
time
you
out
turn to
anybody
the
who
first page, Your Honor,
takes the conversation too
and I
far in
think
argument
we
back
got
and
to bring
forth.
it on
If it's
this one.
causing
This is
problems in
the
chat,
second-
I'm going to time you out.
The largest paragraph on the page there.
If you have some
The one that
questions about it,
starts after
I can
that
time you
report
out
was
until
made?
this is
Yes,
over. We're
yes,
trying to
Your Honor.
focus.
The fourth and fifth sentence says, the dependency court made the decision to keep Maya Kowalski at Johns Hopkins Hospital. We agreed that we would add to the end of that sentence, after October 13th.
Wouldn't it be on October 13th? Because isn't that what the dependency court...
Actually, to be really clear with you, the order is entered on the 14th, but it's one of those shelter orders that has the nunc pro tunc. They were taken into custody on the 13th at 2:30 in the a.m.
Because the judge did this like at 2:30 in the morning.
Yeah.
If I remember correctly.
Some judge did this at 2:30 in the morning. I'm not clear about who that was.
And
2:30 in the morning. We're not sure what's going to happen. We've got to wait and see.
Recall, but
we'll talk about it.
normally they would then go to first appearance.
And actually, before first appearance, they went to a shelter hearing
at 9 a.m. that next morning.
The next day on the 14th. So on the 14th is when he said, when basically it's not that he's keeping them there. They're just going to. It's a continuation of that. But he's worried about his false imprisonment claim, which cuts off on the 13th.
Okay, so you want to say after October 13th?
Are we saying the order's the 14th? I guess we should change these dates to the 14th.
No, because the order has a retroactive finding in it. Because the written order is entered differently than.
Does someone have the physical order I can actually look at?
I do.
The judge wants all the originals. He's like, could somebody just show me what we're talking about? Yeah, this is a lot of little lawyering on little points. Obviously, the elephant in the room is the essay disclosure that just happened today. That's going to be. Both sides have to decide how they're going to handle this. It is the massive issue right now in this case. All the rest pales in comparison, but they're moving on from that as a decision needs to be made by both sides as to how they proceed. I know there's some very strong feelings in the room. Let's try to focus on this a little bit, and we'll get through this. I appreciate all of you. If you got timed out, please don't take it personally. We're just trying to refocus the attention. Sometimes when emotions are high, a conversation going back and forth too much can bring out some angry words or name calling, and we just wanted to put a stop to that.
Okay, so the dependency court did this at 2:30 a.m. on the 14th?
On the 13th.
I don't think so.
Yeah. Can I approach, Your Honor? And I can show you on the document.
We'll have court tomorrow for sure.
Okay, sure. Let's see, the clerk's stamp is the 14th.
Yeah, but the front end of a shelter order, it'll tell you when the child was taken into custody.
They will address it.
And in the front end,
This will be
someplace on that
addressed.
first page, there's a statement that the child was taken into custody.
On the 13th.
On the 13th at 2:30 a.m. I think that's normally done with an oral ruling from a court, and then the shelter order normally is later. This is not the first time I've seen an order that looks like that.
Okay, so what I heard Mr. Whitney say is the parties agreed to, where it says dependency court made the decision to keep Maya Kowalski at Johns Hopkins Children's Hospital after October 13th.
Right, and I think that's an accurate statement of fact and law.
Then
then let's go with that.
Can I just say we'd reserve on coming back to this later when we have a chance to look at that order closer. But for now, we're fine. And then I have one more issue when Your Honor's ready.
Yes.
The next paragraph, the third paragraph, it reads, "You have heard witnesses suggest that Johns Hopkins All Children's Hospital took Maya Kowalski from her parents. We think the testimony offered was accurate. We think we object to this being included. We think it belittles our witnesses and prior testimony, and similar to the court's concern a few minutes ago, we think it would simply highlight the issue that has now passed. So we'd object to that first sentence."
I am comfortable with paragraph 3 in its entirety as it's presented here. I think it's accurate, and I think it needs to happen.
Well,
anything else?
I guess we've made our record, right?
I know you don't want it.
You're going to read that
That's
first
the way the ball
sentence?
bounces.
Mr. Altenburn asks when I'm going to read it. Unless there's a reason not to, I think I would just do it at the beginning of the day tomorrow.
Thank you.
Okay. So everybody knows who the witnesses are tomorrow.
Yep, I believe so. I mean, we're communicating with them as much as we...
And we've gotten to my judicial assistant the name and email address so she can get...
Come over and get the email addresses that we need.
Your assistant kindly just emailed us that information.
There we go. Anything else?
Kelly
Since
took
there's
care of
still
it.
9 minutes before 5 o'clock on the day, we're only going to be here half day.
30 seconds. We just need exhibits from our judge.
Do y'all have the exhibit list? Exhibits?
6 months, Dutchy. The 6 month mark.
We'll have it to them within an hour, 5:30, 6 o'clock. She's been here all day. We hope to have a half day soon.
Is it a lot or a little? Is it short? Please do it as soon as possible. And I don't want to start creeping a lunchtime deadline to 5 to 5:36, then to 9 o'clock, and then 11 o'clock. I really want us to get it around lunchtime because they need time too.
I understand. I've been a victim of that, and getting the opposition's information at midnight is no fun. Sleep-wise.
Thank you all very much. We'll be in recess until tomorrow at 8:30 in the morning.
Okay, I realize there's some strong feelings. I'm not going to take
clean up.
calls on what the bombshell that just dropped here today because it's still early. We don't know what's going to happen. There are a ton of questions. Let's switch here. There we go. There are a ton of questions about that. Yeah, there's an allegation. I think right here, I'm just going to put that on screen. Amber posted this. This is probably the most concise explanation of what happened or what was brought up. There was what predicated this in court, and this was objected to by the defense, and the judge sustained the objection. Was previously there was somebody who said, was there ever a conversation or tell you anything about any essay that occurred at the hospital? Okay, and the hospital goes nuts. I mean, the question's not even done. They're like, object, and the judge is like, sustained, because there's nothing in the pleading, meaning their amended filing saying this is what we're suing you over. There's nothing in there that mentions this, and then they ask this question that's basically saying, did this other crime also occur? And so defense, rightfully so, is up in arms. They're appalled. They object. The judge sustains it, and then it seems that that was a couple days ago, and that was probably right after the lawyer found out from the client this event that occurred, and that's the one that Amber's listed here. Amber, I'm not going to take any calls on this. I already said this. It's going to start a firestorm right now, and really we just don't have enough answers to what is going to go on in this case and how they're going to approach it. This is not being pushed under the rug. They are not saying, well, we're not going to deal with that right now. It's something else. It's possible there could be, look at the options. There could be a different trial, right? There could be a different case where they sue again over something else, as in a separate case that they open up with the hospital just for that one allegation. The plaintiffs could come out and they could say, Your Honor, I know it's late, but we're going to file and amend our complaint, our initial complaint, and say we're going to change it. They've already changed it 8 times, right? This would be number 9. And it's been modified since then. Those things have been struck and everything else. So the number 9 would be filed with the court. This basically would be a reset. It would have to go back to that point and be relitigated. The jury would be excused. It would, as the defense probably accurately said, it will set the trial out back in another year. So that's a possibility. There's a third possibility that as defense looks at this and says, oh crap, this looks really bad, they may just settle and say, you know what, it's the publicity we're getting over this is bad, that if we take this to court and fight this, it could just be awful. So there's a lot of different options. We don't know how they're going to handle it. Amber says, wasn't calling about this part at all. Can I pretty please? Okay, if we steer clear of that, Amber, we'll I'll take the call. I said I wasn't going to take any calls on that. But it wasn't that they were holding it back, Rudy. It's that it just barely came up. The lawyer just barely found out. Amber is on the phone. How are you doing?
Hi, I'm good. How are you?
Doing well. Great.
It's been a crazy day.
Probably the most spicy and intense and bizarre and humorous and at the same time shocking day we've had in this trial to date.
I would say in almost the history of us covering trials, but I don't want to quite take it that far. But it's close.
Yeah,
it's been a big day.
It's huge. I mean, we've seen in criminal trials where complaints are amended and charges change a little bit during the trial. But this is a huge thing. What was on your mind other than the elephant in the room?
Other than the elephant in the room, I wanted to talk about Dr. Chopra's testimony.
Yes.
And because there were a lot of questions in chat of what does this mean? Why is this so huge? Why is this such a big deal? So I wanted to make sure that we kind of circled back to that and brought some of that to light. And I'm happy to help with that if you want me to. I can just let you do it.
Let's start with one of the unique things we saw in his testimony, and this is maybe a weird place to start. But there were a couple questions throughout this that was like we're saying, hey, I mean, it's funny. He's a funny guy, but is he crossing a line that could this be reason for appeal? And I don't think it does. It would have to, his behavior would have to rise to the level where it would have impacted the outcome. But the areas where possibly, I mean, he could have been reprimanded or told to knock it off a little bit, is when the jury goes to ask questions and he says no. He shakes his head no. It's a joke, right? It's a joke, but he shouldn't. Right. He shouldn't be doing that. So I think the humor did go too far there. I don't think it caused a problem with the trial. I don't think it changed the outcome. Meaning his humor and his use of it, I don't think it changes the outcome of the court. But it probably, if it had continued, or if he does get called back and it continues, I think he should be told, dial it back. This is a serious setting. Although you're a funny guy, let's keep it focused. Yeah. So, what was the biggest whoop? There it is moment for you in his testimony? Because for me, there are a lot. Okay, yeah. The biggest ones are when the question came out that they basically said, the question would say, based on your professional experience, your expertise, to a reasonable degree of, professional expert of certainty, all those, when they throw in those words and saying, based on the fact that you are the smartest guy in the room on this, what is your opinion? And when he said that there was malpractice, that there was they didn't meet the standard of care, that the hospital was liable, responsible, or caused the condition or made the condition worse in Maya, those moments when he would say, based on everything I've studied, based on everything I know and what has happened and all the reports and everything, the hospital was in the wrong. That, I think, those were the bombshells. I think we had probably 4 or 5 of them drop today, and then various variations of those as well. But it was, it was super impactful. And I think, honestly, and I know I've given him some grief about his humorous approach, but he was, as far as an expert, one of the friendliest and most understandable experts we've seen in any trial. His ability to explain a very complex thing like CRPS in terminology that a jury who just walked in off the street, I mean, not even know anybody who's ever had any symptoms close to this, can understand, can follow, and be along, and his analogies and everything. It's like, my goodness, no wonder they wanted to get in as much testimony with him as possible. Testimony that should come in with Jack, okay? But Jack's not going to have that same warmth with the jury, this, the rapport, that huge resume behind him, 2 doctorate degrees in 2 different countries. Yeah, of course they want to bring in all that evidence that they can into this one, because it's like gold foil stamped when he says it. And anyway, I'm rambling. Brandy, hello, welcome. Did you get a verdict yet, Brandy? Let me know in chat. Anyway, Amber, what was your
something else I wanted to? I want to specifically mention the Nemours testimony now coming in, because defense opened that door. Now,
Nemours was the therapy treatment, physical therapy, I think it was, outpatient or inpatient treatment.
Right, that's where Johns Hopkins wanted to transfer Maya's care for management of the CRPS. Saying, and in court today, they said that they were, crap, I just forgot it. It was right there on the tip of my tongue. That they were specialists in managing CRPS, essentially is what they said. But that is actually not true. It may be now, but it was not at the time. However, the exhibit that the defense put up and made public in evidence, it's been admitted, is a Johns Hopkins record. It was not a Nemours record. However, the Johns Hopkins record specifically mentions the referral to Nemours, and the when you do a transfer of care between 2 facilities, even if it's the same corporation. So let's say you have Children's Hospital of King's Daughters to Children's Hospital of King's Daughters, you still have to have the same.
There's paperwork for the transfer,
procedure.
documenting the transfer of records and the patient and what's going on and the circumstances of the transfer.
Right, from both sides, not just the one that's transferring to another location.
It's one saying, I'm giving you this, XYZ, and the other person says, I'm receiving from you this, XYZ. And so you have a crossover overlap of the paperwork.
Right, so there should be documentation within both facilities. So the documentation that the defense put on was the Johns Hopkins documentation. But you can't have that without having the other piece of the Johns Hopkins documentation, which included the denial of admission for transfer from Nemours for XYZ reason, which is what plaintiff's side ended up winning. Right, but they won it, and that was huge. And the point to that is that if the whole reason Maya was not transferred wasn't just because of Nemours declining the acceptance of transfer. It was also because no parental figure signed the paperwork consenting to that transfer. So neither Jack nor Beata agreed to that transfer of care because of the parameters and conditions listed in why the patient was being transferred, which included Munchausen's by proxy. And they weren't going to sign it, not necessarily just because of the transfer of care to be transferred from facility, but they weren't going to accept those conditions for transfer and agree to Munchausen's by proxy.
Because for a couple of reasons. First of all, they're admitting that, that's basically saying that we're causing the problem. Okay. They're also saying that if these are the terms of the transfer, you're going to treat these conditions, and that's not the problem, right? Treating that condition is separating her from the mom. That's how you treat Munchausen by proxy. You separate them from the person who's causing the problem. And so, of course, they would not agree to that if they knew there was something else, and that's not what it was.
Right. So there was confusion as to why Nemours didn't accept the transfer. It was kind of twofold. Parents didn't consent to transfer of care, and Nemours wasn't going to accept it because of
the MBP.
Munchausen's by proxy. Now, Munchausen's by proxy was not a definitive diagnosis. It was a suspected condition. So Beata was actually psychologically evaluated and was found to not have Munchausen's by proxy. But once you put in that blurb earlier of what plaintiff was trying to get doctor to say about, in your experience, when something is entered into a record, and he had said it earlier, he wasn't necessarily trying to get him to say, if there's Munchausen's by proxy, you're likely not to get a transfer of care from the, receiving facility. That's not what they were going for. They were actually going for the repeat statement that he made earlier of, once it's in the record once, it's hard as crap to get it removed.
Yeah, and we did get that evidence in a little bit. That question,
we got that earlier.
We got that earlier, saying how difficult it was. Once something, it's like written in stone, okay? And so much of the doctors, and we saw this in chat, so much of the paperwork that transfers down the line as a patient's care progresses is copy and paste what was before, paste that, then add to it, right? So it's basically it becomes solidified through layers and layers of copy and paste.
Right. So there was a lot of things at play there when it came to the Nemours stuff, and I think a lot of the chat got confused, and I had to go back a few times just to make sure I heard it right. But I mean, they were absolutely right. The defense brought in the Nemours note on the Johns Hopkins side, which completely blasted that door wide open. Yeah. And they have to defend that. They weren't necessarily saying no to transfer of care for CRPS treatment. They were saying, no, I'm not signing this in agreement with what you stipulated as to the reason why you're transferring.
Yeah. Amber, I appreciate. Yeah, sorry.
An admission.
I appreciate you sort of clarifying that. The hospital really wanted to make it look like it was the parents who were refusing treatment for the daughter. Just saying, we're trying to treat her, the parents won't let us. And there was so much more to that. The doctor on the stand did such a good job in responding to those questions. First of all, being truthful and still appearing like he's telling the truth, and maintaining that open, dialogue and the jury still sees him as truthful, I think. But at the same time saying, I can give you the answer you're asking in a yes, no, or a true, false, but there's so much more to that. It's not accurate. I need to say more, and he was able to address that beautifully. I think the defense scored very few points on the cross-examination, and they needed to score points on this cross-examination because so much came in against them. I think it was almost like a game-winning type score that occurred during this one witness.
I don't think the defense got I don't think they recovered as well as they needed to. I really don't.
Yeah.
In my personal and professional opinion. But it was so crazy how insane the doctor's testimony was getting with a lot of the stuff that they wanted to keep out, but they opened the door and brought it in themselves. Without realizing they did it.
It's so fun to watch lawyers do that, to fight so hard to keep something out, and then through their own, trying to prove a point, open the door that ends up bringing all that back in. We saw this in the Murdaugh trial. We saw this in several others, but it's happening here. But Amber, thank you so much for helping us understand this. I appreciate the way you were clearly able to lay out the facts this afternoon that we know so far. We're going to keep an eye on this and see how it goes. Thank you. Appreciate all you're doing. You sound great. You sound better than you did this morning, as a matter of fact.
Thanks. Just a tip for the title of the video, since Maya didn't testify today.
Yeah, well,
we might want to update it.
I'll change it right now. That was not clickbait. We were told that Maya was going to testify because one of the doctors, they were going to have two witnesses, right? The doctor that testified today plus one other that was going to take up all the day. And they said, well, we're going to have Maya testify instead. But didn't happen. Thank you very much, Amber. Have yourself a fantastic afternoon. Appreciate all your help. You can take the rest of the day off.
Thanks, y'all. I'll talk soon.
We'll see you. Bye. All right. Let's see. I've got people calling. We're not going to take phone calls. I made a special exception for Amber. Can you guys text me if possible? That would be easiest because we're pushing 5 o'clock already. Hang on, Mrs. R.A. has a question. What's up? what do I read into how the jury is feeling based on the questions they're asking? This is something I want to ask Chat as well. Specifically with the doctor, we had a lot of questions come in that were insightful, and one of them I thought would lean towards a win for the defense when they're asking the doctor, how can you say in one time that this is a rare thing, and the other time that, how can you be so confident in that sort of question? I don't remember exactly the word of that one, but that question seemed to be as somebody that might be siding with the defense on this case. But the rest of them, just very insightful. I think most of them expounded on what the defense tried to get in, or sorry, what the plaintiff tried to get in. And it was basically a win after win after win. And the way the doctor handled the question from that one person who had how can you say it's rare and at the same time this, I believe he handled that in a way that was polite and that seemed very truthful and authoritative at the same time, saying it's rare because of, by definition, this is what makes it rare. But anyway, it was good. It was fantastic. It was wins all over the place for Maya's team, and then coming in at the end of the day with this late disclosure, which could derail the entire case. This could end in very abruptly without resolution. It could end and be reset as this goes back to the drawing board, or to the negotiation room, depending on what happens here. New question for Mrs. R.A.
You're saying that the lawyer just found out about it, but Mr. Upper Torso was saying that the essay was in the original documentation. Here's what she says. She said, the lawyer just found out about the claims of essay. The lawyer says when he read the notes, he took it as something else, or took it as an examination type thing, and didn't think there was something to it. That's how I gathered that bit of information. What changed his mind was in the last couple days, Maya recounted this experience in more detail. Very specifically with what happened, and then he was able to corroborate that with a witness that she had told this experience to, and that is why he brings it up now. So huge bombshell. No one else was in the room. No, there wouldn't be video footage in the room for the patient. All of that came from Maya. Yep. All right. So, yes, that is a criminal thing, but it can also be a matter for a civil case. It would have to be a criminal thing if they could pinpoint or locate the individual that's involved, and that might be very difficult to do. But yeah, it could implicate the hospital in the oversight of the patient in the care, especially if they had, by court order, taken custody of her, and this occurred. That would be neglectful in that way, and then make them responsible. So yes, this trial is going off the rails very quickly. No chaperone was there. That's what we heard. Oh, chat is not on screen. Sorry, I took chat off screen. I've been putting all your comments up, just so you know. Everyone who's said a question in the last few minutes, I put every single one up on the screen. And I'm sorry. I don't know. Hospital must have cameras in the hallway. This is years ago. It may be very difficult to get security camera footage from a hallway, and also, I mean, you're asking a girl who was 10 at the time to recount the exact date and time that something occurred of one person walking through a hallway. It may be very difficult to prove this. Megasaurus, thank you very much. I renewed my membership. Love this channel. Thank you. Good to have you here, Megasaurus X. Let's see. Heard the jury. I think the jury heard what they heard by now. Attached some emotion to it, and that's what it is. Matt, sorry, what? Why bring it up? They don't need to prove it. That's if there's enough proof. They brought it up as a question, and I don't know the reason this came up. The whole reason this came up. First of all, yes, plaintiff did raise the issue, but the defense
in the way the court addressed the objection when they first said, "Has there ever been any accusation of SA at the hospital from Maya?" The way they addressed the question was, objection sustained. You can't go there. And they now, days later, defense is saying, "Hey, Your Honor, going back to that issue, we need something stronger. We need more from you. Instead of just saying sustained, we need you to go back and to say there has never been, and ever, there's not in the complaint. There's no allegation. This is not one of the accusations. This is not something we're litigating. This is not involved in this case at all." And that's what they wanted the judge to do. And so they say that to the judge. Judge turns to the plaintiff and says, "What's your thoughts on this?" And he's like, "Well, about that." Okay, and so that's how those doors just flooded. He says, it's as good a time as any to say it now, and it's a late disclosure, so it's all sorts of problems. Matthew Harris says, "Honestly, I don't think the hospital can argue surprise here, since the information was contained in records that were exchanged in discovery, notably docs from the hospital." Yeah, that's. Here's my thought, Matthew. Does this mean settlement? Do they want to go down this road? If that's the case, give Mrs. R.A. the mic, says Be Kind Tiger. She doesn't want it. She said, what was that? I promised myself I wouldn't. She promised she would not get on the mic because she used her mean words yesterday.
But can the hospital be held criminally?
Can the hospital be held criminally liable for allowing that SA to occur? Yes. Yes. When they claim they're taking care of her, yes, I believe if there's proof, if that can be proved, yes, they can be held liable. I'm not sure about criminally. I mean, how do you put the hospital in jail? Because the hospital said they're yeah, but somebody has to be in cuffs for that, right? Which one do you lock up? CPS in cuffs, says Mrs. R.A. Okay. Goodman Law Firm says there's tons of footage in her room hospital bed. I wonder if there's footage from her room and it needs to be found. I don't think it's hospital footage. I think there's like people filming, especially the physical therapy, the families there as she's making, she's able to use the walker for the first time and stand up and turn and sit, or put her heels on the ground. I think the videos like that we've seen, I think that was more like a cell phone camera filming. I don't think they had a camera in the corner. Jessica says, "Shush, I want to hear Mrs. R.A." She's sitting on the floor right here, comfortably, crisscross applesauce, right? No, she's not. She's in timeout. Ivan says, "Sorry if I made anyone upset. Never mean it. Love you all." Ivan, we love you as well. You have very strong feelings, and we did delete, and I think we put you in timeout for a comment that we wanted to make sure did not end up in your arrest. That's all. But thank you, and I appreciate everyone giving everyone space to share their opinion and then be able to step back if it goes a little too far. All right. Goodman Law Firm hired for the prosecution. Judging by the tenure of the defense attorneys, I don't think settlement is an option. They seem especially obstinate, says Matthew. So Matthew, you're saying they're going to fight this to the end? Just for Matthew, what's the odds that this goes all the way to right up to jury deliberation and then they say we'd like to settle? What are the odds? I mean, for whatever amount, what are the odds that they attempt a settlement after the case is completely, fought? I think they can do it at any time. The parties can withdraw anything.
But they can't.
You need the mic. She's going to talk. Here you go.
Okay, no fake curse words today. I just don't think that they can pursue this, even though it makes me so irate at what has happened. You can't. It's all based on one girl's memory, and she was a little girl at the time, and was it even a doctor? There are just so many unknowns that unless we get some other evidence, I just don't think that they could win this if that's the only evidence that they have. So throwing out the entire court case based on the idea that we want to include this, I don't think they can. And I think the defense knows that, and that's why they're being just the devil's spawn. I'm done.
Devil spawn. See, she starts getting into her mean words, and then she gets rid of the mic. Matthew Harris says 2% chance on the settlement prior to verdict. That's very low. The defense heard the same jury question you did, and they're going to roll the dice. Remember, defense is paid by the hour. Yeah, but remember, as the bombs started dropping, figuratively speaking, from the witness, the doctor witness, and the worried expression says all of them are almost like biting their fingernails, like subconsciously they're sitting there like that. They're glances at each other, and then one picks up the phone, starts texting rapidly. I don't know. They're definitely worried. I think this was a loss and in an area they expected to get at least some wins or reduce the damage a little bit. So I think they made a bit of they lost more ground than they anticipated today, I think. Okay, in the documentary they showed surveillance footage. It might be. I mean, this might be something they go into, and so Goodman Law, if they find footage, they're definitely going to wrap this into one big case. They don't want to separate these out and say, well, we'll sue for this over here and this over here. If the more they can roll into a ball and say, look how bad the hospital was, look at how many different ways they failed this child, look at how they treated the family. If they can get every single thing they can and roll this into a big snowball and start it down the hill towards the jury and just let it pick up steam, and that's how you get a huge settlement. And so if there is evidence where they can prove that this happened, and I think they do have to have more than what they have right here with just Maya and one witness. It's I don't know. It's gonna be difficult. But if they can prove that, I think the hospital would have to settle.
Okay, can I have more?
Mrs. R.A. promises to be good. Here we go.
That is false. I did not promise to be good. Okay, here's the thing, and I know this is just philosophical, and it's not really what this case is about, but I keep coming to this, that fundamentally what this case is about, whether it's CPS or the hospital or anybody else, we are arguing amongst ourselves and in general in society. We're arguing about what the role of parents is in anything. What's the role? When a parent disagrees with the medical community, does the medical community suddenly win? Do they usurp the position of the parents? Well, what about CPS? At what point do they step in? Who gets to decide who the end? What are you laughing about? For a mic. You know what? Funny story. I think I actually own all of these mics. But I think that's what it comes down to, is that parents, really good parents that I know, have had their children be, can I say that word online? Essay has happened to their children through no fault of their own. And so I don't feel like I can say, the hospital, curse you, you're wrong, you caused this, when I know that even excellent parents, this happens under their watch. But fundamentally, if you want to be a hospital or any sort of government agency or a church or a neighbor or whatever who steps in and says, now I am superior to the parents, then you better, gosh darn, y'all hear me? You better be willing to pick up all of the responsibility associated with that. The end.
That was a mic drop moment. Thank you, Mrs. R.A. My wife is absolutely amazing. If you cannot tell, I married up. I don't know why she doesn't want to come on camera, but she has her own YouTube channel where she discusses, believe it of all things, homeschooling. I think she should get into to commentary on some of these things as well, because I love her opinion. She is smarter than I am in just about every way, and definitely more eloquent and extremely well read. So Matthew Harris says #community property state. So all these mics belong to you. Mrs. R.A. owns it all. Yes, her link. Did I put it in chat? She is homeschool ground zero. By the way, it's just homeschooling. She says, if you're not interested, don't come. Total side by here. I love Recovery Addict and Mrs. R.A. how you two interact. This coming from a lawyer who works with marriages that have trouble communicating. So thank you. That's a great compliment. All right. Anything else we need to address today? We've had a long day. We've been here quite a bit in trial for quite a while. New homeschool law class. I combine the two. Mrs. R.A. for president. So there we go. I don't think she has any desire to be involved politically in that, or even on camera, she says. Let's see. I think we're good. I think this is it. Look, today has been crazy. Has been spicy. It has been. We've had some of the best lawyering we've seen in any case to this point. We've got a judge, I think, that is trying his very best to be impartial and is doing a good job of it. I think a lot of cases, in this case specifically, a lot of the objections, the law is sort of on the side of the hospital, more so than it is of the family, which is frustrating. Mrs. Ari says that means it's a bad law, but that's, I think that the hospital is winning a lot of these objections on those grounds. Mrs. R.A. on the podcast, I think we should do that. Thomas actually talked about interviewing Mrs. R.A., so we'll see if we can talk her into it. Get Mrs. R.A. her own mic fund. I would need a new desk.
Get Mrs. R.A. own mic fund.
It would. She says no. She's shaking her head. As I'm in Texas. I've got wireless mics. I could plug it in and get her mic'd up. We've got those right here. We can make that happen. We just need her on camera as well. All right. Anything else we need to say? Ayden, I skipped your call. Have you taken a deep breath? Are you ready to call in now? Won't take no for an answer, says Thomas. Desk, road board, cable number 48. Yes, I've got the openings right now, so we could plug a mic in. We just need a desk and the cable. I've got the cable. I've got the mic. I need an arm. I need an arm and the desk. And a camera. And a willing spouse. So I'd need that. Ivan's on the phone. Give me 1 second. Let me bring him on here. Ivan, my friend.
Yeah, I'm not going to get into the specifics of the claim, but I just want to know from like a legal standpoint, like how do they reconcile that? Like where do they go from that? Like I don't really know. Like was the jury present?
No, jury was not present. They have not heard that. Everybody but the jury right now knows this. So it was. I mean, it's aired in open court. It's in public. This is where these sort of things are litigated. It's frustrating. It's awful. But this is where it happens. Right. We've seen other cases that have allegations like this that are aired in public court as well. We try to steer clear.
For sure.
We try to pick cases that don't have this because it's a very difficult topic.
Yeah, and I don't want to get into like the specifics of the actual claim. I just am more worried, or not worried, but like thinking of like the legal aspect of it. Like how do they decide or how do they reconcile who gets to hear that and when and how and all that. Like maybe Matthew can weigh in on that. But like, is that going to be battled out tomorrow? Like, where do we go from there? You can't just unring that bell from the judge's standpoint either, right? Like, he can't just pretend he didn't hear that. I mean,
right. The judge is doing what he's doing every time he's presented with a dilemma, and this is what makes being a judge the best job in the world. You can have other people do a lot of your work for you, and so he says, okay, you've presented me with a problem. You're asking me to rule on it. What do you want me to say? What do you want me to do? He's not just going to get up there and with all his wisdom, choose something. He's going to say, make a proposal, make an argument, defense. What do you think? And then he'll weigh the options and say, based on what I've heard and based on the law, here's my decision. And right now, the judge is saying, I want to hear what you guys think. Give you a couple days to think this over, and so it may not be tomorrow, but it may be early next week when they come back and say, this is how we propose that we go forward on this issue. And so we're sort of in a holding pattern on this topic, even though it's a huge topic and it's a game changer.
Yeah, and my other question is did the defense know that was coming? Because isn't there an obligation for the plaintiff to tell them that that's coming? Like, where does that Brady come in? You know what I mean? Like,
it's a late disclosure for sure. But the defense it's late disclosure from the plaintiff to the defense, but the plaintiff gets a pass in some regard because they just found out themselves. And so this was raised to them in the last 3 days. This is what they're saying.
Okay.
So we have to play with the information they're giving us. It was raised to them in the last 3 days, and they did some investigation to see if there was any truth to this, or if there's any corroboration or other witnesses or anything, and they found some, and now they're bringing it forward.
All right. So your wife and house on the line. You think they just learned this?
I think these lawyers on both sides have read every word of every one of those 7,000 pages of hospital records. I think there is no stone been unturned on this one. I mean, you've got $200 million riding on this. I think they probably had some inkling of this being potential, and probably
This is a shell of all bombshells.
Maybe
Okay? Like,
maybe intentionally waited to this moment to find out. Okay, is that
Right.
okay? So they didn't know before, but they waited till right now to find out.
I don't know what I don't know.
Yes,
Right? Like, I don't know.
they have plausible deniability.
Yeah. So that's my only standpoint is just the legality of it. Forget the allegation itself. We could go into that forever, but just the legalistics of it all. I just have a hard time believing they've known this girl how long. This case happened how many years back or was filed. You're trying to tell me that she just mentioned this 3 days ago.
After the prompt of saying, "Hey, we're about to release this witness." Yeah. Is it? Are you cool with this? And she's like, "Well, there's one more thing."
There's a great big bridge in Brooklyn I want to tell you too.
I'm saying the timing is very beneficial to the defense, or to the I keep saying defense, to the plaintiff.
Right.
Somebody, hang on. Who did this?
Dang it, you Matthew.
Steam locomotive heart with ribbon rice cracker giraffe ear of corn sailboat bubbles monkey covering ears monkey covering eyes monkey covering mouth.
There we go. I think he said you've said enough, Ivan. I think that's what he's trying to say.
Is this his way of trying to... What's that called when Congress does it?
It's a filibuster. He's filibustering. I was going to say I'd love to hear possibly from Nicole on this if she's able to call in. I'm not sure if she's at a point where she could call. She's got a couple some legal arguments. So Ivan, if I can let you go and say thank you. Good to talk to you, and I appreciate your kindness and how we timed you out unceremoniously.
Hey, it's all good. I needed some time. All right.
I think we timed out a few other people as well on accident while we were trying to click on different ones. So please don't be offended if we accidentally misclicked and timed you out.
All right, love y'all.
Did I time you out? I might have timed out Mrs. R.A. so now I'm in trouble. Love you, Ivan. Catch you later. We'll
Have
see
a great day.
Bye.
Yeah, bye.
I'm not sure if Nicole's at a point where she can call. She might be busy, but it would be interesting because I don't know what this is. Res judicata, the res judicata or res judicia. I don't even know how to say it. It's Latin, says Mrs. R.A. She knows. And Ivan, Matthew, thank you very much for the great super chat with all the emojis. Congrats on your huge win, by the way. I'm going to go back and replay those emojis. Give me just 1 second because I want to hear the full. Let's see, turn that off. Turn this here. I'm going to go back and hear what those emojis sounded like. Just 1 second. Here we go.
Globe showing Europe and Africa smiling pile of poo milk tea with tapioca pearls and straw carrot pickup truck field hockey stick and ball hot beverage hot pepper roasted sweet potato fondue pot, hand orange covering ice, steam locomotive heart with ribbon rice cracker giraffe ear of corn sailboat bubbles monkey covering ears monkey covering eyes monkey covering mouth.
There you go. So now you have the whole story. I'm pretty sure you just... using emojis provided a synopsis of War and Peace, but that was really good. So thank you. Matthew says I hit send too soon. That was only chapter 1. Good stuff. All right. I think Nicole is in the chat. I'm looking to see if Nicole's it's in the documents and the evidence. Let's see. I could guess the trial brings many memories back, but maybe she didn't even remember it. She was only 10 years old. Must have been traumatic, just thinking out loud. Oh, it's everything they've said could be true. There's a possibility. I'd say it's a smaller possibility, but a possibility that that this all happened and is a complete surprise to the defense. Please set your alarm tomorrow morning, as the judge didn't say. Didn't the judge say they're starting at 8:30? Okay, so I will not be late tomorrow. I will not be late. I'll be on time. We won't be late. Our win made the front page of the local newspaper. Picture headed to burner. Sounds good. I can't wait. Can we share that on the podcast, Matthew? That's just good news. Or on the live stream, either way.
I was kicked back, taking it easy.
Matthew just wrapped up a huge long case with I believe a multi-million-dollar settlement, which is a huge win.
I have a question for Matthew.
Matthew, don't go anywhere. Mrs. Ari has a question for you.
I was just wondering, is this case more interesting to him because of the CPS?
Is this case more interesting to you, Matthew, because of the CPS angle and the involvement of them? Okay, I'm not sure. Let's see. I can call, says Nicole. Awesome. Now would be great, Nicole. Now would be fantastic. I'd like to hear what you're getting at with that res judica. I don't even know how to say it. It's essay of a child case, unfortunately, but it was a $26.8 million verdict. It's good to see justice done there. Sorry, says Matthew Harris is buying dinner. Hopefully that's a huge win for the victim there. All right, I will share the picture when we get it here. Oh, there it is. Hey, look at that. Let's send this to the laptop. Well, Nicole is calling. I think Nicole's a little bit behind in chat or in the timeline. Okay, media. I'll show a picture. Here we go.
Call from.
It's Nicole.
It's Nicole. Nicole, this is Recovery Addict. How are you doing? Thanks for calling in.
Hi, Scott. Of course, my pleasure. So I'm sorry I'm walking my dog. Hopefully it's not too windy or noisy.
It sounds great. Tell me a little bit what your thoughts were on this, specifically from a legal standpoint.
The bombshell this afternoon. Well, there's a lot of issues. First, a lot of people were saying and surmised the hospital didn't know. But from what I understand, after hearing the argument, is that not only is it in the documents and the record, it may be already in evidence.
So
they're saying it's a surprise. Yeah. Correct. From that particular issue, because her statements were corroborated by a mental health physician and someone else. I can't remember, a nurse or somebody documented it near the time that it happened. Plus, she disclosed it to a different mental health provider a couple years later.
Yeah.
So there's something somewhat contemporaneous with when it happened. So the defense is saying, well, you didn't plead it, and therefore it's surprise, which was why I was thinking they should try and backdoor it in through their battery claim. In which, I mean, they could make an argument that it's a battery, and so they should have anticipated it, especially if it's in the documents. The problem with her trying to sue later is, I don't know if you saw my comments on res judicata, but res judicata prevents somebody from relitigating against the same parties for the same causes of action. But it also includes causes of action that arose out of the previously litigated causes of action.
So they have to put it in one. So they're not going to.
They have to. Correct. They have to get it in, or it's gone. They won't be able to redo it. There may be a criminal prosecution for it if it's proven at some later time. But they won't be able to sue for it civilly.
So if the judge looking at this and for whatever reason says, hey, we're not going to allow it because of late disclosure or whatever,
right?
Their only option is to amend their complaint, which will reset the whole trial, right?
They can't at this point. So if they try to dismiss, they're going to be on the hook for Johns Hopkins attorney's fees, because once the trial starts and you dismiss, they're considered the prevailing party under law. So that's not going to happen. Their only option at that point is literally to just, they're going to have to waive that claim. It's just never going to get litigated, which is what Johns Hopkins is going to want, for sure. So, but like I said, that doesn't mean they can't be, found criminally, liable, whether it be the physician, if they can figure out who it was, or the nurse that was supposed to be watching, or, there could be something there, but again, that's difficult. Like you said, it's so far down the line. Now, what'll be interesting, and I remember specifically from the documentary, was that they were surveilling her in her room. And you could actually see some of the surveillance footage of her in her bed, laying in her bed. And if they can find it, that could be really devastating. But again, if I was a plaintiff, I wouldn't be trying to bring it in as part of, this new allegation, I would be saying, hey, this is a battery.
Yeah.
And just leave it in the battery claim. It's no different from the claim that the CPS worker put her on her lap and was stroking her back.
Yeah.
It's the same type of thing. So I think they could maneuver it, but plaintiff's counsel's a little discombobulated most of the time.
Yeah. So
at least that one.
Unrelated question for you. I'm going to put on the screen right now. Matthew Harris had this huge win. He's in the newspaper. The Texarkana Gazette says victims of child molester are awarded $26.8 million in civil settlement. That's
congratulations!
Huge.
That's amazing. That's amazing. I told him yesterday, fingers crossed there's no appeal that stays collection.
Yeah. And that is the case. A lot of these times when there's a civil settlement, it doesn't mean that one party walks out of the court with a check from the other one. It usually is the beginning of a long process.
That's the judgment. If there's a settlement, you're going to get your check. If it's a judgment you win,
okay.
Good luck.
Yeah. So you still have to fight that one. Thank you very much, Nicole. Appreciate that.
Yes,
love having you in
course.
chat and your expertise and knowledge in this field. So thank you. And
My pleasure. I'll get back to my channel soon. I just, I've had a lot going on, so
can't wait.
Needed a break.
Can't wait to see
Life.
it. All right. Thank you, Nicole. Have a good one.
Thanks, everyone.
We'll see
Bye.
you. Bye. Awesome. Great to have Nicole on and Matthew, two great lawyers, friends of the program. All right. I don't know what time we're starting tomorrow. 8:30. So we've got to be up early. I will set my alarm. I won't sleep in tomorrow. I can tell you that. We're going to wrap it up tonight. We've got a lot to think about. There's a lot of things that the lawyers are working on. Talk about people who are not getting sleep. They thought they were going to have a half day today and get out and be able to work on stuff, and it ended up going till 5. They're going to be chasing their tail throughout everything as they're trying to line up all their witnesses and get everything in order and provide all the documents that the judge is requiring them to provide to the defense on the other side. It's funny, even though everything's been shared, really, barring this late disclosure, all the documents have been shared from one side to the other. There is so much that the judge is requiring the plaintiffs to say, of that, that 9 boxes of material, what page are you going to be using? And you got to tell the defense so they can prepare, because you can't just prepare a defense for 9 boxes of data. So they fight over that a little bit. There's a little bit of gamesmanship there as well, but it'll be fun. I don't think the fights are over. The spiciness is going to continue. Obviously, we have some huge, heavy, weighty issues that need to be settled, and we'll see how the plaintiff, how Maya wants to proceed with this, and her lawyers want to proceed with this, as well as how the defense wants to handle it as well, and then we'll see where the judge decides in the middle. So tomorrow, let's see. I'm Eastern. So right now, if this helps, it is 5:42 p.m. So tomorrow at 8:30, I think court starts. So we'll probably start at 8:15. Mrs. R.A.'s like, I'm cutting into her exercise time, and she exercises here with that TV. So that means not much sleep for her. But I'll buy you a treat of some kind.
Oh, that's excellent.
To make up for your lost exercise time, ice cream or something. All right. Thank you very much for being here. It is wonderful. This is the best place to watch true crime, and it's because of all of you. It would not be the same here without you, for sure. Thank you. I've got a ton of messages I have to reply to. Just a ton. I'm going to go. Never mind. My kid's holding a football, and apparently we're headed to the park. So we're going to wrap up. We're going to go play before it gets too dark. We've got a little time. We got an hour. We're going to go play at the park. Tonight when you go home, please hug the people you love. Smile at someone, make it the day just a little bit better, and please stay safe till we go live again tomorrow morning at, it's 8:15. 8:15. I'll put the placeholder up early. How about I put it up tonight? That way you can hold me accountable to it. I don't know when we're going to give out internet, because if you join the placeholder now, if you join the thumbnail now and chat's turned on, it clears off over time. So I don't know who's going to win the internet tomorrow, but I'll put it up tonight. You guys can talk a little bit. Mods, don't worry about managing that. Don't feel like you have to manage the chat in the thumbnail before we go live tomorrow. It should be fine overnight. You guys all deserve a break. You've definitely earned it.
Is that correct?
That's correct. Who did that? Who did that? Was perfect timing. Thank you all. Have a great evening. Be kind to each other. We'll see you tomorrow. Bye.
Don't miss the forest from the trees. Scratch all that. I apologize.
Oh, it stole it.